accommodation in respect of item number 1, my lord. Only for the day, my lord. Actually, today I am tied up in 3 other matters in 3 different courts. If it starts, it will take some time, my lord. I am prepared to do even tomorrow also.
Tomorrow not possible. We'll have it next Thursday.
My
This is only the tinkering with this thing that your sale deed would be good
only to
insofar.
the extent of 1/4.
That is only the.
Yeah. No, Thursday বিতারিখ নয়। June, Thursday 5 তারিখ, ঠিক আছে? I'm deeply obliged.
Next Tuesday, top of the list.
Thursday,
No, next Tuesday.
Tuesday.
Next Thursday is the High Court matter, Guwahati High Courts.
Oh.
Lordship.
oh,
Tuesday, Lordship. 3rd.
Tuesday I'm not there.
No, but it's
Can it
only
be
that thing.
Thursday?
But Mr. Chaudhary, that is the order which I'm going
No,
to.
I know it, my lord, but then Tuesday I'm not in town, my lord, that's why. Any other day, my lord. 3rd?
A third.
Yes.
Third is next Tuesday.
Tuesday. 3rd is Tuesday.
Oh, then it's okay. Then it's okay. I'm not there on 2nd. It's okay. I'm deeply obliged.
My lord, this review matter was permitted to be listed yesterday, but for want of convention, it was not brought to the Honorable Court. So we want to make it argue today at 2 p.m., my lord.
Review.
Review matter with the condonation that this is not filing condonation matter because we are in good impression that if we explain the delay, then that would be sufficient. But now we have filed along with another petition for some interim protection.
We'll can have it tomorrow.
Lord, actually, title exam case is pending for beta. So unless some order is passed, it will be difficult.
It is pending. When is has the writ of delivery of possession issued?
Yes, that is on 30 or 31st.
Has the writ of delivery of possession issued?
That matter will be passed on that day.
So 30, 31st, we have time. Why not tomorrow?
Tomorrow.
Not today.
My lord, I beg to maintain an IA civil filing an MSc appeal, my lord, to be listed. The IA is relating to, my lord, it's a condemnation of delay, my lord, of 15 days. I am with the respondent, my lord. The matter was last listed in 2024. After that, the matter has not come up, my lord. Any day in this week, my lord, it's convenient.
11 June? 11 June? We are in the last week of this May.
My lord, please.
For admission, item 2.
Yes.
Yes, my lord, this is a testamentary appeal against the judgment passed by the
You are?
we are the daughters of the testator. And we were made parties and we were residing in Mumbai. And no notices were served on us. And the case proceeded against the ex-parte against us. And the probate was granted.
Oh, I remember that case.
Yes, my lord.
Where you have no business out there, means you were not there with your father.
Yeah.
Yes.
Then how do you challenge it?
No, but it is the notice that was served on us by newspaper publication. That was not properly. there prior before the trial court was there. There be notice as they are residing outside Silchar. Notice is to be published through paper publication. And accordingly, paper publication was made in a English paper, Daily Telegraph. And Telegraph has no circulation in the state of Maharashtra.
In Maharashtra,
Yes,
there's no circulation.
no circulation. Therefore, we had no knowledge about the pendants of the case.
Telegraph was there, was it a Mumbai edition?
Yes, there is a Mumbai edition.
Hmm.
And the
Telegraph has a Mumbai edition.
My lord, another thing is that paper was not on the record. That publication of newspaper, that paper I want to verify, that paper is not in the case record. That is the very vital.
No, are you saying that when the court directed paper publication,
Yes,
paper publication was made and the court was not brought, nothing was brought to the notice of the probate court, that there was a notice, there was a paper?
no, there was a paper. That paper was they have filed before the court. But on verification of the record, I found that that paper was not available. Therefore, it is a Guwahati publication, Calcutta publication, or Mumbai publication that was not known.
Record has come?
Record has come.
How record to come? How is the record here without even the appeal being admitted or appeal admitted?
Okay, to go.
Because there is already an order. Order dated 31/7/2024, 14,
yes,
categorically says that OPs are represented. Simply, this is the document by which the paper was filed.
Yes. But paper was not there.
Why the paper is not missing? Why is the paper not available? Mr. Olaska?
We have there filed an application saying that paper should be kept on record.
There's an order to that effect.
Yes,
In
yes.
fact, this document is also there,
Yes.
which contains 9 pages. But why the paper is not available?
Whatever, my lord, the paper should be available, but since it is accepted and the learned trial court proceeded ex parte on satisfaction that service has been completed. So the onus now is on the other side, and they can procure the paper from the office of the newspaper itself. And this is a proceeding, they should go for a proceeding under Order 9, Rule 13. It's a question of facts, their evidence should be taken. And so, and otherwise also this is not maintainable, my lord. This is an appeal under Section 299 of the Indian Succession Act, my lord. The provision says that only an order passed under the provision of the Indian Succession Act can be appealed from. But this is an appeal in effect challenging order, ex parte order, which is passed presumably under Order 9, Rule 6. CPC. So this is not maintainable.
What is the order challenge here?
In effect, this ex parte order has been challenged.
No, we are challenging the judgment.
The judgment, let the probate be, they've challenged the probate, the granting of the probate.
Yes.
Yes, they have challenged in form, but in effect, your lordship will be deciding on the validity of the ex parte order that is passed under Order 9, Rule 6.
Order 9, Rule 13.
The ex parte order, my lord, passed by the learned trial court saying that notice service is complete and now the proceeding go ex parte. So that order passed under Order 9, Rule 6. And your lordship effectively, in fact, will be deciding the validity of that order here in this.
But
So-
but if there is a judgment and decree which is passed ex parte,
Yeah,
that is appealable.
that is appealable, but under the circumstances and facts of this case, my lord, it needs appreciation of evidence by the learned trial court. Since it is accepted that the notice has been served and the proceeding went ex parte, so the learned trial court was satisfied, and now it is presumed that the learned trial court was correct. So the burden of proof is upon them, and they can prove if their assertion is true by calling the original copy of the newspaper where it is published from the office of the newspaper. So this is an exercise that can be done in the trial. So this should be a proceeding under Order 9, Rule 13. Only under that provision, this exercise can be done.
So you mean to say, we have to admit it, that the service is duly complete.
Yes,
Here, the petitioners herein or the appellants herein has, if they are challenging the impugned order
yes,
of granting a probate,
yes.
has to challenge on the merits without there being a written statement.
Yes, if they want to maintain an.
Because they
appeal
have
under
not
Section
gone under
290.
Order 9, Rule 13.
Yes,
So and if they have not gone under Order 9, Rule 13, the question of passing a judgment ex parte,
yes,
when that avenue is available,
yes,
they have two remedies.
yes,
When there is a judgment and order, judgment and decree passed ex parte,
yes,
either move under Order 9, Rule 13
yes,
or file an appeal.
yes.
An appeal is permissible.
Permissible per
Under
se.
1996, the appeal is permissible.
Permissible per se.
Now, they having challenged it on appeal, they have to do so without their written statement, without their defense.
Yes. They cannot say that this order by which the proceeding went ex parte is not valid. They cannot challenge that. they only can challenge this probate, granting of probate on merits.
on merit.
Merit.
That too without uh, a written statement or a,
Yes, yes. Because that is
without
valid.
their defense.
Yes, that is valid. That order is valid until and unless that order is set aside, they cannot file a written statement. So and
Now, if the
on-
order is passed under Order 9, Rule 6.
yes,
It is not appealable.
it is not appealable under section 299, my lord. This is my submission.
Okay.
And
If-
there is an
No, no,
authority.
understood. If it is not appealable.
Yes.
And this appeal is being taken under what provision? 299.
299.
With the CPC appealable, applicable?
Yes,
CPC will be
yes, as to
applicable?
appeal. Yes, provision of CPC as to appeal would be applicable.
Then why not 105 would not come into the picture? Because you see, an order passed under Order 9, Rule 6 to proceed ex parte is not an order appealable under Order 43.
Yes,
If it is not appealable, can it not take up the ground of objection in 105?
yes, but this is not an appeal under 105.
No. 105 is not, it is not an appeal. It gives you a thing that any appeal which is any order
Yes.
during the proceedings of a suit,
Yes,
if it cannot be challenged
yes,
under 104,
yes, and 104, yes.
then these grounds of objection can be taken in an appeal which is filed. Read 105.
Yes, but my submission is that since the provision of section 299 clearly says that only order passed under the by virtue of provision of the Indian Succession Act. So an appeal filed under this section, in this appeal, they cannot agitate about an order passed in other provision of CPC.
Now, just for example, they were not allowed to adduce evidence.
Yes.
Let us take a very extreme case. That the person who was seeking the probate,
Yes.
he becomes the plaintiff
Yes.
when there is an objection being
Yes,
filed
yes.
as regards the
Yeah.
validity of the deed of the will.
Yes.
He becomes the
Yes,
plaintiff.
plaintiff.
He have been given the opportunity to adduce evidence.
Yes.
Whereas the other side, the court directly goes from there to the next state for arguments. No chance given. In an extreme case, then what does he do? He cannot challenge.
If your lordship,
If the procedure has been wrongly done,
yes, yes,
or-
they can challenge under
So here the
provision of
procedure,
CPC
therefore-
151.
so the procedure is now being challenged out here
Yes,
on the basis that it proceeded ex parte against me
yes,
and without a proper notice.
yes.
That's his case.
That is their ground. Yes.
Now, that is one ground. But the most important ground which he has to satisfy this court is that the will was not valid.
Yes. On merit.
He has to choose that. Now he doesn't have a particular defense, or there is no statement in that regard
Yes.
in the petition.
Yes.
In the probate proceedings, he has not filed his written
No,
statement
no, no.
challenging
defense.
it.
Yes.
challenging the will. Now, in a circumstance where without notice to the legal representatives,
Yes.
the probate was being granted,
Yeah.
would the granting of the probate be good? Or is he only required to move under Order 9, Rule 13 and not on an appeal?
It can be, the procedure can be challenged, my lord. Procedure can be challenged under the provision of CPC and
So
if the
his
procedure
only
is not
ground is,
proper.
his only ground is that no notice was issued,
Yes,
or I have not received the notice
yes,
And under such circumstances, I have been stopped from challenging the will. That is his ground.
Yes.
Your submission is, the records show that there was a newspaper
Yes.
which is duly recorded in the order dated 31
Yes,
1
31/7/2014.
2014.
Yes.
And the record also shows that there was a newspaper which
Was there,
should
yes.
have been there on
Yes.
record, and there is already a stamp,
Yes.
and the court have duly recorded.
Yes.
So unless and until that, mainly because that document is not there now,
Yes.
would not nullify the
Yes,
entire
could not
judgment.
nullify. Yes.
That's your case.
Yes. And I,
On
my
merits,
submission is that
merits your case is, if the ex parte order is proper
yes,
and they having not contested the will,
yes,
they cannot file an appeal.
yes. Yes, but there is no defense. There is nothing.
That is what
Yes.
they have to contest the will.
Yes, they have.
They having not contested the will,
Yes.
so the appeal on other grounds cannot be maintained
Yes.
because there is nothing
Nothing on the record. Yes.
there. So his entire case hinges upon the order passed
Yes,
ex parte
31/7/2014.
31/7/2014.
And it until and unless it is set aside, so there is they don't have any case.
No. This court can very well set aside that also.
Yes.
But the question is, the moment I set aside, but the
Yeah.
question is whether when the court have duly recorded that the service is complete,
Yes. Yes.
notices were issued.
Yes.
There were also documents to the effect by
Yes, yes.
postmaster also
Yes,
to that effect
Yes.
that the service was also, this was delivered.
Yes.
Then also the court
And
went
the court was
into the
satisfied
question
that-
of
yes.
what you call that newspaper publication.
Yes.
And the court was satisfied.
Satisfied.
Why should this court interfere?
Yes. Oh, without any basis of any evidence adduced by them to the contrary.
His only ground is, look here, the records, there is no,
Yes, that is the ground.
so merely because there is nothing, the document is not there on record,
It
although
doesn't
the
mean-
first page of the document is already
Yeah,
there.
It doesn't nullify the order dated 31/7. It doesn't mean that this order is invalid.
That is your case.
Yes.
But the whole thing is this, the publication of newspaper. Whole thing is hinges to the publication of in the notice publication in the newspaper. But that paper is not available in the record.
But but Mr. Sharma, it is duly recorded in the order.
No, it is duly recorded in the order, but in which paper and which date, that was not mentioned. And my lord,
Then why didn't you challenge on the order 9 rule 13?
that we don't know. Oh, order in rule 13 because the both ways are open to us, my lord.
So therefore, here we are, why should we say that the order is wrong? The order categorically says, prior to that, there is an application filed under 151 for taking steps by way of paper publication. Court permits it, and thereupon, the next day, the paper is being produced and the paper is kept on record. Surprisingly, the first page of that particular document on which it is being filed is already there. The remaining 9 sheets are not there. But the court duly is satisfied and records it. Unless you say that that court has, for personal reasons,
Yes.
have adopted a different thing, how can you say that?
No, my lord, when we came to know about the decree
If
passed,
somebody have taken away the paper now from the records, then are they to be blamed for that? They have duly filed it, which is kept on record. That is the orders passed by the court.
but that is our case, and we have stated in our memo also, page 5.
Now,
That is
you are submitting that there is no telegraph
not earlier.
in Bombay.
Yes.
So what is your basis to say so?
Well, they are residing there in the Mumbai. They have stayed.
No,
The,
what is your basis to say that there is no telegraph publication in Bombay? Merely stating would not do.
Telegraph is a national paper, my lord. National paper, it has circulation in Bombay. And I think there is a Bombay edition also. Even if there is no Bombay edition, Kolkata edition is available here in Guwahati, and it is available in other cities also, all over the India.
So how can we proceed?
well, there is no circulation of telegraph in Maharashtra. Therefore, my submission before your lordship.
No,
will be-
understood, barely stating would not do.
Yes.
You have to come up with better particulars. You have to come up with that particular, they have a, what you call, this register of newspapers.
Yes.
They have a particular thing as regards how much, there's a
Circulation in which
particular
place?
word out there. There's a particular agency. Forgot. What is the name of the agency? I did a case for that. These newspapers, they fight for the TRP.
Yes.
The TRP is on the basis of a particular poll being conducted by this agency.
Yes, there is a records that agency maintains about which newspaper have
How much
many
is the circulation?
where,
Everything is there.
which place.
What is that agency's name? Yes,
RMI.
Audit Bureau of Circulation.
Yes.
Now, these Audit Bureau of Circulation provides these details as to whether there is any circulation in Mumbai. So if you are making that submission, you have to come up with these details. There's no circulation. And they have maintained it. This is not today's agency. This is an old agency. And this is how you get the advertisements. Advertisements a newspaper gets on the basis of this. They have this is under the RNI, Register of Newspapers of India. So this is done in a circulation. This is how it is done. Audit Bureau. They will very well show. Tomorrow you want to see which newspaper is selling the most in Assam. You can get the details. And what was happening 10 years back. Yeah. And I know this for the fact that Audit Bureau of Circulation was there in 2014 because sometime in 2000, tsunami came in 2009. Huh?
Right.
Yes.
Yes.
At that point of time, as a lawyer, I was doing a matter here on the fight between Times of India and Hindustan Times as regards their rating out there in the, they were supposed to issue this Audit Bureau of Circulation was to issue. And if it is issued, it changes the advertisement.
Yes.
So then also these people were there. So therefore you can find it out very well.
Yes.
This is how you have to make your case.
Yes.
Otherwise,
Yeah,
there's
therefore,
no way out. what
Therefore,
you are
my
saying.
submission is that they can do it under Order 9, Rule 13 method. That would be the appropriate procedure because we may need to examine the authority who will produce these records and all those things. And that is not appropriate for the this honorable court to when
No,
engage in
he's,
such
no.
exercises.
Mr. Sharma's submission is very specific.
Yes, ma'am.
There is no circulation of the newspaper Telegraph at Mumbai.
Yes, ma'am.
And as such, he had no knowledge.
Yes.
So the question is to see as to whether it is or not. Now, if it is so, then he may also have the option of withdrawing
Yes.
the appeal and then during this period be taken into account for filing an Order 9 Rule 13. He
Yes.
may do that.
Yes.
This
Yes.
court is not going to search that
Yes,
aspect
that is what
without
my-
their defense.
This is my submission.
It would not be proper. So first, if he can find out from the Audit Bureau of Circulation that there is no newspaper publication of Telegraph in Mumbai, with that, because they have they produce the data from time to time. Then they can very well know. That is the only way out,
Yes.
Mr. Shah. Otherwise, the only other way is to withdraw. Withdraw and file Order 9 Rule 13. Because without your defense,
Yes.
this is absolutely. Because if you file an appeal, you have to come up with this, look here. You cannot say that here, that there, because otherwise the court records it. This court cannot presume that the record, some document is missing. It doesn't make the entire thing go.
So
Audit Bureau.
since they don't have any defense, so there is no use to go into merits of the.
Here we
the
can't
case.
go to the
Yes,
merits.
yes. So
We have to admit, because there is no contest to the will.
Yeah. So that's why I
And,
submitted.
and the best part is, where is the contest? They were
Yes.
not bothered with the father all along.
Yes, yes, yes.
They didn't even come to his funeral rites. Now, when the question of property comes, they have arrived,
yes,
isn't
yes.
it?
That is obvious for even from the
Yes.
departments.
That is your admitted case in
Yes.
your other matter which I passed an order.
Yes.
They went with the mother. There was a dispute between the mother and father. And these two appellants, they went with the mother.
No, you did not even come for his funeral. That is your case in the other matter which I have
Yeah.
duly recorded in my order.
Yes, yes, that is in detail, your lordship has recorded.
And I said that applications of file of abatement and all does not arise, taking into account that once a person concerned is already a legal representative. Where is the question? Chalo.
Let me verify it may be posted for summary after verification.
Or get some document to the effect, file an additional evidence, because without any, you cannot just make it and come up with that nothing out there. Your client should be more active enough. The best option, as Mr. Lasko submits, is your order 9 rule 30. That is the best option. But if you want to go ahead out here, there will be a case of additional evidence that these are the documents which are there and these documents are not there. As of now, there is nothing. Merely stating would not do. So you want time. Heard Mr. A.C. Sharma, the learned senior counsel, assisted by so-and-so, appearing on behalf of the appellants. Mr. O. Laskar, the learned counsel, who appears on behalf of the respondents. Mr. A.C. Sharma, the learned senior counsel, submitted that the proceedings, the probate proceedings, being probate title suit number 65/2014, had proceeded against the appellants herein without proper notice, inasmuch as there is no circulation of the newspaper Telegraph in the city of Mumbai where the appellants reside. Per contra, Mr. O. Laskar, the learned counsel, appearing on behalf of the appellant, respondent, submits that the order passed by the learned trial court dated 31/7/2014 makes it clear that there was a publication of newspaper, and on the basis of the publication of the newspaper, the court was duly satisfied that the service was duly effected. He therefore submitted that the court, having been satisfied with the said document and having proceeded ex parte against the appellants, the instant appeal should fail, taking into account that they did not contest the will. First, further to that, the learned counsel submits that merely stating that the newspaper the Telegraph newspaper is not published at Mumbai, is not circulated at Mumbai would not be sufficient. It has to be supported by some documentary evidence. The learned counsel submits that in the instant appeal, there is no documentary evidence also adduced in support thereof. He therefore submitted that this is a fit case for dismissal of the appeal at this stage itself. Mr. A.C. Sharma, the learned senior counsel, appearing on behalf of the appellant, submits that he would obtain instructions to list this matter again on, I think today, on 10th of June 2025.
Hello,
Supplementary item 21.
Yes,
Lordship,
argue.
Lordship,
Do you mean to say that I'm going to hear her request? No.
No.
You are the petitioner, argue. By that time I deliver the judgment, ask your senior to come. Yes, next.
so basically one question remains, Your Lordship, there is a suit under section 6. And in bypassing the judgment, Your Lordship, the learned trial court has decided the question of title also, saying that the documents which we have produced, there is a forged one. But it will affect in future course. It come later on a lot. So their allegation there is that they have been dispossessed by the plaintiff side, sorry, the appeal petitioner hearing on 19/3/2025.
What are the dates?
19/3/2005.
You are Solia?
Look,
No, you are?
I am for the defendant,
You are the defendant. Okay. Solia says that, huh?
Solier.
Okay, now your case is, what is the case of the Solia?
That
You were dispossessed when?
19/3/2005. We have dispossessed her,
2005.
dispossessed the company.
19/3/2005.
Right.
And when was the order passed?
That
When were the proceedings filed?
on 17/9/2005.
2005. So it is filed within the period of 6 months.
Lordship.
Okay.
If it is counted,
No,
Lordship,
it is 6 months?
6 months,
6 months. Because here they don't use 90 days, so it is
No.
6 months.
6 months.
So 6 months it will come.
It will count.
Now therefore, the question is whether she has been able to prove that she have been evicted without due process
Lordship.
on 19/3/2005 or at the best 17/3/2005 till 17/9/2025 2005 they have been evicted. So this is the period.
This is the period.
Now have they able to prove that?
Lordship, they exhibited the FIR.
FIR
FIR
dated
is exhibited of dated 19/3.
19/3 FIR.
So Lordship,
Where is the FIR? Is the exhibit?
copy of Lordship, I am coming to that. The plaintiff exhibited suspension, order dated suspension.
My goodness, what these people have done to this suit.
Lordship. FIR dated 23/2005.
PW1.
PW1.
Who is PW1? Ruby Hazarika, I am the director of the plaintiff company.
PW1 is Ruby Hazarika Lordship.
Private limited company having its registered excellence. The director. So he was director. Done with all this. Only concern is- Why they have made this into a suit? '23, 2005 is the FIR.
23, Lordship.
Then they have been evicted again on 14/4.
It is their claim, Lordship. Their claim is that, Your Lordship, after filing the FIR, a proceeding under section 144 was started. And according, they get the possession. Without their having any order from the court. Their claim is that on 19-3, we dispossessed them. And thereafter, they initiated proceeding under section 144. And on the strength of that proceeding, they got the possession. Thereafter, on 14-4, we have again dispossessed them. But there is no such order regarding repossession.
So you could not break anything in the
No.
cross.
Lordship,
She maintained that.
maintaining.
Then what is wrong? So by anyways, 19-3-2005 and 70 also comes within the ambit of 6 months.
That's
And 14-5-2005 also comes within the
Within the
ambit
6
of
months.
6 months.
Six.
Okay. Now this is one. Now how does the trial court look into it? Therefore, this fact corroborates the allegations of the plaintiff that on 14-5 the defendant dispossessed the plaintiff in one. The other witnesses so and so. This was like a property providing taken away by. So what is wrong with the order?
Lordship, one. Section 6, their claim is on the basis of title. So far the plaintiff is concerned, they are also claiming that property has been bequeathed to them. And that
But this being a section 6 proceedings, this will be only limited to recovery of
regarding
possession.
dispossession, regarding dispossession. And whether it has been filed within time.
That's all.
Lordship. But
And it
in
is being
deciding
found
the, Lordship,
from the discussions made in the foregoing issues, it requires no further discussion for holding that Iman course of action so and so. And the relief is entitled to recover possession of the Iman or Godown. Defendants here and so are disturbed, perpetually restrained from disturbing the peaceful possession of the Iman by the plaintiff company. Perpetually Iman is only subject to filing of suit.
should,
So this is the only modification required.
Lordship. Lordship. And
You will
Lordship,
be evicted.
and Lordship, what happens in deciding this suit in para 27, it has been stated in para 27, relevant page, Lordship, 53. 53. And it starts from 27 and it start this clearly 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. This clearly shows, Lordship, got it. This clearly shows these papers have been obtained by the defendant with the nexus of the revenue officials.
Now, these are not necessary. I'll
Lordship.
say, make these observations.
Lordship, that observation is required.
Yes, madam. We have no objection.
Sir, is still on legs on another boat.
Let him be.
Can be at 2 p.m.
No. Subject to a cost of 50,000. Okay? No. I'm dismissing his petition. But now I'm modifying the order to the effect that the order directing recovery of possession is good
Lordship.
in your favor. However, the perpetual injunction so granted is limited to the effect that they cannot take away the possession of the year, disturb your possession without following the due course.
Lordship. Lordship.
You see, in a suit for under section 6, it is limited.
Limit.
A person having been dispossessed without following the due process can file a suit within 6 months. And the court's finding is also limited to that extent that yes, the suit was filed within 6 months and they were in possession on such and such date. And Therefore, the court's power is only for the purpose of directing recovery of possession, but and for permanent injunction, question does not arise. That they cannot be dispossessed without following the due process.
Look,
So now they have to file a suit for recovery
look,
after getting the permission.
look.
That's it. Win-win for you. I'm only not putting your senior's name. That is the loss. Heard Mr. R.K. Bhuiya, the learned counsel appearing on behalf of the petitioner. Miss
And because
so and so, who appears on behalf of the respondent. Petitioners and respondent. No? First. The revisional jurisdiction of the court has been invoked to challenge an order dated 13/7/2015 passed in title suit number 313/2005, whereby the learned court of the civil judge number 1 Kamrup, Guwahati, presently the learned court of the civil judge Kamrup Metro at Guwahati, for short, the learned trial court, had decreed a suit under section 6 of the Specific Relief Act in favor of the plaintiff. First, the facts involved in the instant proceedings. Now, for the purpose of deciding as to whether the jurisdiction so exercised by the learned trial court was in accordance with law, this court finds it relevant to take note of the brief facts which led to the filing of the present proceedings. One, Debobola Cholia, since deceased, purchased the plot of land at measuring 4 bighas 3 katha 2 lechas from one Randhir Roy Chaudhary by the registered deed of sale dated 3989, dated registered deed of sale bearing number 3989 dated 16/6/1961. First, the said land had been specifically described in Schedule A to the plaint. In the year 1970, in the month of December 1970, a partnership firm was constituted, being MS Soliha Warehousing Company, having its registered office at P-21 Golf Club Road, Calcutta 33, with a view to starting a tea warehousing business at Guwahati, wherein the partners were late Debobola Cholia, where number 2, Indrajit Cholia, number 3, Ranjit Cholia. Subsequently, Srimati Ruby Hazarika Rekha Basu and Minakshi Basu became the partners of the partnership firm, and Sri Ronjit Cholia retired as a partner. In the year 1971, the Schedule A land was leased out by late Debobola Solia for utilization. Schedule A land was leased out by late Debobola Solia for to the partnership firm, and boundaries were constructed, leaving vacant an area approximately 1 biga 16 lechas. Full stop. It was further mentioned that at the time of death of late Debobola Chalia, she bequeathed the Schedule A property in favor of MS Soliha Warehousing Company Private Limited. Private Limited or what? Company. Huh?
Later on, it has been converted to limited company. Initially, the partnership that is converted.
Huh?
Lordship, paragraph number 9, that subsequently the partnership firm was transferred into a company, namely Messrs. Solia Warehousing Company Private Limited.
At this stage, it is relevant to take note of that the partnership firm was converted into a private limited company. The partnership firm, Soliha Warehousing Company, was converted into a private limited company and was registered as, incorporated as Soliha Warehousing Company Private Limited. That is the plaintiff. Full stop. It is the specific case of the plaintiff in the plaint. No, full stop. In the said suit, no, full stop. Here. It is the specific case of the plaintiff in the suit that the plaintiff was in possession of the Schedule 1 land, Schedule 1, na?
Schedule A.
Schedule A land. Till 19/3/2005.
Right.
But on that day, the plaintiff company was dispossessed by the defendant. Defendants through the defendant number 4. Full stop. Now again, made it complicated like anything.
Paragraph 22, Your Lordship.
Schedule A is 4 bigha.
4 bigha. Schedule C is now disputed land.
Huh?
Schedule C is a disputed land.
Schedule A being 4 bighas bound. What is Schedule B?
B, the land of Schedule A.
So what
Now,
are they asking for? Recovery of what?
for Schedule C, 1 bigha 16 lesser.
Mr. Bhuya,
Got it.
tell me one thing. Is this actually a suit under Section 6?
They ought to have filed a suit for declaration of right title, interest, and recovery of possession. Because they got back the possession. As
Then why
the-
did they pay so much of court fee? Come to page 11.
11 rupees.
Ah,
The value at rupees 100 and at gram court rupees 11 is paid.
total court fee of rupees
So,
5,000.
5,553.
Why was this paid?
Lordship, before that, maximum ad gram court fee on the that case is valued at rupees 41 lakh, and half of the ad gram court fee of rupees 41 lakh 41,000 is paid, and half of the maximum court fee of rupees 11,000 amounting to rupees 5,500 and 5 lakh is paid as per Schedule 1, Item 2 of the Court Fee Act 1870. The injunction is valued at rupees 100 and 11 is paid.
So why so much of it is paid?
So far the Section 6 is concerned, half of the amount is to be paid.
No, we have to give a description. From the materials on record, it is seen that there are facts which leads to the filing of the instant petition. Huh? From the materials on record, it is seen that one Debabola Solia, since deceased, had purchased a plot of land measuring 4 bighas, 3 kotha, 2 lechas by the registered sale deed number 3989 dated 16/6/1961. Pustam. The said land has been specifically described in Schedule A to the plaintiff. Pustam. In the year in the month of December 1970, a partnership firm was formed in the name and style of MS Soliha Warehousing Company, which included various partners was formed, having partnership firm was formed in the name and style of MS Soliha Warehousing Company. Full. Amongst the various partners, one of the partners was late Debabola Solia. Full. Late Debabola Solia, during her lifetime, leased out the Schedule A land to the said partnership firm with a permission to make construction like tea house godown, staff quarters, etc., and also to construct boundary walls over the same. Full stop. In the year 1980, the partnership firm accordingly constructed a boundary wall surrounding the warehouse, leaving vacant an area approximately 1 bighah 16 lechas. Full stop. This 1 bighah 16 lecha of land, which remained unbounded, is the Schedule C land. Full stop. A perusal of the plaint in title suit number 313/2005 states various facts, but taking into account that the instant proceedings is the proceedings under Section 6 of the Specific Relief Act 1963, for shock the Act of 1963. The relevant facts would be that the plaintiff, who is the owner of the Schedule A land, by virtue of the land being bequeathed by late Debavola Soliha in its favor, and was in possession over the land on 19/3/2005, was dispossessed by the defendants, and more particularly the defendant number 4. Under such circumstances, one of the directors of the plaintiff company filed an FIR on 2005, which was registered and numbered as 2005. Was that registered?
This is not number, your lordship, that is exhibit.
Exhibited, no?
Exhibit lordship, it is exhibit 11. 12 lordship. 12 copy of the FIR dated 23/2005. Serial number there.
An FIR was filed on 23/2005 before the officer in charge of Dispu police station, stating inter alia that on 19/3/2005 at around 3 p.m., the defendant number 4, along with 200 people, entered into the vacant plot of land and ousted the laborers and security guards forcefully from the quarters situated on the plot. Full stop. The said FIR was received on 23/2005. Full stop. Subsequent thereto, another communication was written on 7/4/2005 to the officer in charge of Dispu police station, giving further details as regards the incident dated 19/3/2005, and also the fact that the FIR was already filed on 23/2005. It is very relevant to take note of that on 12/4/2005, the subdivisional magistrate Kamrup Metro have initiated the proceedings being case number 259M/2005 on the basis of the complaint so filed on 23/2005 and 7/4/2005. And accordingly, drew up a proceedings under section 144 of the Code of Criminal Procedure 1973, thereby restraining the defendants from entering into the disputed land and also from erecting any type of construction over the disputed land to prevent any further breach of peace, as well as to maintain law and order in the area with immediate effect and until further orders. Full-stop. It is the further case of the plaintiffs that on 14/4/2005, the plaintiffs was handed over the possession. And on the very date at 3 p.m., the plaintiffs were again dispossessed. And it is under such circumstances, the suit was filed on 17/9/2005. It is also stated that the order so passed by the learned magistrate, a learned executive magistrate, dated 12/4/2005 was put to challenge before the learned court of the sessions, Kamrup, in criminal revision petition number 43/2005. And the said proceedings was dismissed. The materials on record show that pursuant to the filing of the suit, which was registered and numbered as so-and-so, the defendants filed the written statement denying to the contents of the plaint, and also further stated that they have been in possession of the suit land much prior to 19/3/2005. And as such, the proceedings under Section 6 of the Act of 1963 was not maintainable. Full stop. On the basis of the pleadings, the learned trial court framed as many as 5 issues, which being relevant is reproduced herein under page 45-46 or so. First, on behalf of the plaintiff, "13 witnesses were examined. And on behalf of the defendant, 2 witnesses were examined. Both the parties exhibited certain documents. You did not do anything, no?
Okay. We have exhibited
ABCD.
ABCD.
First, the learned first appellate court, the learned trial court, on the basis of the evidence, came to a finding that a plaintiff was dispossessed on 19/3/2005. Came to a finding that the plaintiffs were in possession of the Schedule C land as on 19/3/2005, and they were dispossessed on the said date. And further, again on 14/4/2005, the plaintiffs were dispossessed. And it is under such circumstances, the suit was decreed, decreed by holding that the plaintiff is entitled to recover a previous possession of the land and property described in Schedule C of the plain, which forms a part of Schedule A land, along with staff quarter and godown. And the defendants, their men, agents, laborers, etc., were perpetually restrained from disturbing peaceful possession of the Schedule C land by the plaintiff. The said judgment and decree was passed on 13/7/2015. It is relevant to take note of that though the judgment and decree was passed on 13/7/2015, the instant proceeding was filed on 19/1/2017 with a delay of 518 days. The said delay was condoned by this court on 30/4/2025 and by an order dated 30 by another order of the same date. This court fixed up the instant proceedings for disposal today. Mr. R.K. Bhuyan, the learned counsel appearing on behalf of the petitioners, submitted that the learned trial court had adjudicated the said proceedings as if the said proceedings was a normal suit for declaration along with consequential reliefs. The learned counsel further submitted that there are observations made in the said judgment and decree, impugned judgment and decree, impugned judgment and order, wherein which touches on the title. The learned counsel submits that a proceedings under Section 6 of the Specific Relief Act of the Act of 1963 is only for deciding as to whether the party who has filed the said proceedings was in possession within 6 months from the date of filing of the suit and was dispossessed without following the due process. The learned counsel therefore submits that the observations so made on the question of title by the learned trial court is not in accordance with law, and it is beyond the jurisdiction conferred upon the court under Section 6 of the Act of 1963. Per contra, Ms. So-and-so, the learned counsel appearing on behalf of the respondent, submitted that as this court is exercising the jurisdiction of a revisional court, The question which is required to be looked into is as whether the learned executing trial court had exercised its jurisdiction within the manner envisaged by the law. First, the findings of fact so arrived at by the learned trial court on the basis of evidence clearly show that on 19/3/2005 and subsequently on 14/4/2005, the plaintiff was dispossessed from the Schedule C land, that too without due process. First, under such circumstances, as the suit was filed on 17/9/2005, the learned trial court was within its jurisdiction to decree the said suit in the manner in which it has been done. She therefore submitted the question of that this court may not exercise its revisional jurisdiction in the present proceedings. Anything else? Anything else? No. This court have given an anxious consideration to the relevant submissions so made by the learned counsel appearing on behalf of both the parties and have also perused the materials on record, including the evidence so adduced by both the parties. Full stop. From the evidence so adduced by the plaintiffs, it appears that on 19/3/2005, when the plaintiff company was in possession of the plaintiff company who was in possession of the Schedule C land was dispossessed, and thereupon the defendant thereupon again on 14/4/2005, the plaintiff was dispossessed. Full stop. The learned trial court, on the basis of the evidence, had come to that finding. Full stop. Consequently, there is no perversity in the said findings. Full stop. This court further takes note of that the proceedings under Section 6 of the Specific Relief Act are in the nature of summary proceedings. And what is required to be adjudicated in such proceedings is as to whether a person concerned who is in possession of possession of an immovable property, not specific relief. Possession of, what is that term? Section 6? Of land or what? No. What does it say?
Lordship, should property, person disposes within the consent of immovable property.
Of immovable property. A person who is in possession of an immovable property, if
Otherwise-
dispossessed within a period of 6 months, otherwise by following the due process. What is the term used? They don't use due process.
Otherwise, then to due course of law.
Otherwise, then in due course of law.
Law.
The suit can be filed under Section 6 of the Act of 1963 within 6 months from the date of dispossession. Full stop. Therefore, what is required in the proceedings under Section 6 is for the learned court to ascertain as to whether the person concerned who is complaining of dispossession was a possession of the suit premise of the immovable property on the date of dispossession. B, was dispossessed on the date, was dispossessed by the other party. C, was dispossessed by the other party otherwise in due course of law. B, it'll be over. C, whether the suit was filed within 6 months from the date of dispossession. Full stop. Taking into account that the scope and ambit of a proceedings under section 6 is limited to the above aspects, there cannot be also observations so made in such suit as regards title. And any such observations so made cannot also be construed to be observations for observation affecting the title of any of the parties. First, considering the above, this court, this court have duly taken note of the judgment passed, impugned judgment and decree passed by the learned trial court, and is of the opinion that there is no infirmity in the said judgment and decree. First, however, this court finds it relevant to observe that any observations as regards title so made would not impact any of the parties in future litigations or act as a res judicata. First, accordingly, the instant proceedings, this court finds no merit in the instant proceedings. First, this court also finds it relevant to observe that the decree so passed for perpetual injunction accordingly, this court finds no merit in the instant proceedings for which the instant proceedings stands dismissed. First, before parting with the record, this court, for the sake of clarity, observes that the decree so passed shall not preclude the respondents herein to file appropriate proceedings for recovery of the suit land if so advised.
Regarding perpetual lordship.
Huh?
Perpetual injunction, yes. The decree for perpetual injunction.
Ah.
That is to be modified, your lordship. Other, page 59, your lordship.
No, that is what I was looking into.
Lordship.
Here, what is say perpetually restrained from disturbing peaceful possession.
Of the scheduled sea land.
That is why I am not touching it. Peaceful possession. So I am giving you that liberty
Lordship.
to file here. Record spirit.
Although my lord, LCR has received my lord, service is not yet started.
Dusty? Have you taken Dusty?
Usual courts as well as registered, my lord. Usual courts as well as registered and ordered, my lord. Trustee I have not done.
Why?
Usual, my lord, it was ordered usual courts as well as my lord. Trustee.
Taking into account the appellant is given the liberty to take steps by way of Dusty.
Trustee, to take my lord, trustee also, my lord. One. Trustee also. Trustee also. My lord, some mistake we have committed. Visual course and registered course we have taken, my lord. Trustee we have not. In fact, my lord, there are some problem also, my lord. Trustee may not receive by the parties, my lord. That is-
So you file an affidavit to that effect.
That I will take, my lord.
Are you not the plaintiff?
My lord.
Your suit has been dismissed.
Yes, my lord.
Then there was some delay.
Res judicata was
the ground of residing at that.
So under such circumstances, why there is no urgency on your part?
There's some urgency on my side.
It is seen that the service upon the respondents, number 1 and 2, is not complete. Moreover, no steps have been taken for the respondent number 1 and 2 by way of dusty in spite of the liberty so given to the appellants. Considering the above, list this matter for only after completion of service upon the respondent number 1 and 2.
May I take-
This matter has gone for a 6. Can't help it. You have not taken what steps is required. If you would have taken by way of dusty, they would have.
I'll
I
make a
mean, I
mention
could have
after
remanded.
completion of service.
Sorry, can't help.
Alright.
Stay matter item 19.
Transfer from
My lord, from Bajali to Kokrajan.
Bozali to
Kokrajan, my lord. District and Sessions is Kokrajan.
what do you do?
My lord, petition is unemployed man. She's of 27 years of age. And she has an infant child, my lord, of 5 years.
Who is Narayan Burman?
My lord, the father of the respondent.
Huh?
No,
Narayan
my lord.
Burman.
I'm sorry.
What is the proceedings of TS conjugal right pending before the Munsib Bar? Now it is before the district judge, Kokrajan.
Yes, my lord. My lord, earlier we had preferred a transfer petition bearing number
Chal.
74 20.
You have filed your written statement.
My lord, it is stayed, my lord. My lord, the matter is stayed, my lord. As of yet.
I'm
It is not
asking you,
filed.
have you filed the
No,
written?
no, my.
Okay. Ekon transfer allow kori dibo. Now please line. Appearance of both the parties on 14th July. On 14th July, on which date the petitioner shall file the written statement in the said suit before the court of Kokrajan. Or at a line like last, taking into account that the respondent, in spite of steps being effected, have not entered appearance today, comma, the learned tribunal, court of the district judge, Kokrajan, before proceeding with the said before proceeding, shall issue notice to the respondent, who is the plaintiff in the said proceedings.
Deeply obliged.
Item 20.
Taking transfer from Aizawl, Lanet, Irrigation District Judge Aizawl Mizoram to the family court. Silchar Lordship. I have some objection, Lordship.
Aizawl to
Silchar, family court.
what is your objection?
Lordship, my objection is, Lordship, that it will, I am ready to pay her all the cost of, Lordship, for her traveling, Lordship. And
Why?
Lordship, because there's a treat to my life, Lordship, because earlier occasions, Lordship, she used to treat me, if you come to my place, I will, it is a statement made by my the respondent to me, Lordship, but I have not noted it down, Lordship. So he has an apprehension, Lordship, so he does not want to travel to Silchar, Lordship. That is the only thing which is not, that is effective, Lordship. That's why I have not written also. But Lordship, otherwise, Lordship, may I pray, Lordship, that
What does the petitioner do?
nothing, Lordship, to my limited knowledge, Lordship.
Transferred.
Lordship, may I pray, Lordship, let me be transferring in a neutral place at Guwahati, Lordship, possible, both sides will be, Lordship, convenient for both the sides. And I'm ready to pay all the.
You are going to come from Silchar to Guwahati and she is going to come from Silchar to Guwahati by flight. Tell me, give me a good idea. Then he is going to transfer Silchar. None appears for a petitioner Lekhi Dibo.
And Lordship, the better to also dispose of my only prayer is husband wants to take back also her, Lordship, but
Go there, tell him,
may I pray for sending the matter to mediation before his honor court,
go
Lordship?
there. In Silchar, go and tell them that you want to.
For hearing, item 8.
Any date, Lordship, to
Oh,
which-
this
which-
week it is 14th July for her to file her written statement.
Lordship, let it be on 11th of July, Lordship, if possible, Lordship.
Are you going there?
Maybe, Lordship. I will.
Okay, 11th of July.
Oh, Lordship.
Vicky?
Item 8 for hearing.
Mr. Counsel, you inform this man, the counsel for the petitioner.
My lord, as per the last order dated 25/3/2025, the appellant took time to file substitution. But as of now. no
Who
appeal.
died? Who died?
25 March 2025. They are not taking steps for substitution, my lord. The appeal may be
Who
dismissed.
died?
my-
None appears on behalf of the appellant on call. Mr. I. Talukder appears on behalf of the respondent. Further to that, it is also seen that on 25/3/2025, the appellant was supposed to take steps upon the respondent numbers, take steps on account of the death of the respondent numbers 1A and 1B. Was required to take steps on account of the death of the respondent number 1A and 1B. However, no such steps have been taken. Taking into account the non-appearance of the appellants today, as well as not taking of the steps, this court can presume that the appellants have lost interest in the instant proceedings for which the appeal stands dismissed for non-prosecution, dismissed for default, full stop. The records be returned to the learned trial court, be returned by the registry.
Interim order early assembly.
Within 90 days, after 90 days from the date of the present order.
Item 9.
I'm the respondent plaintiff lordship. Respondent plaintiff lordship here. Lordship, this is a concurrent finding lordship. This is a 2013 matter lordship. It was admitted in 2013 itself lordship. Then it has come up for hearing for the first time lordship.
And appears on behalf of the appellant on call. So Mr. So-and-so appears on behalf of the respondent. Numbers? Respondent numbers
All the respondents.
on appears on behalf of all the respondents. It appears therefore that the appellant is lost interest in the instant proceedings for which the appeal stands dismissed for non-prosecution. The records be returned after 90 days from the date of the instant order.
Item 10.
Landlord tenant matter, landlord tenant matter 9.
In RSA,
No, my lord, CRP 85 of 2018.
I mean, RSA
No,
number
my lord,
370.
A2. Oh. No, my lord, sorry, it is item number 11. Item number 10 to cause this.
What suit is this? Oh, you are for the respondent?
I am for the respondent. No.
Where is the other appellant? No one.
My lord, in this case, Mr. Moore is appearing, in fact.
Huh?
Mr. R.K. Moore is appearing, my lord, in fact, in this case.
For the other side?
No, for the
No, some
respondent.
R. Chaudhary is appearing. Miss R. Chaudhary is appearing. More is appearing for respondent numbers 1A to 1D,
Yes, my lord.
3A to 3D. You are appearing for? It's your suit.
My lord.
Is it your suit?
No, my lord, Kali Prasad Sil and 3 others. Oh.
The suit was
For declaration.
dismissed.
recovery.
Yes, my lord.
Suit was dismissed and against that an
No,
appeal
my
was
lord, the
filed.
suit was decreed on 8/9/2014, my lord.
Suit was decreed
Yes, my
in
lord.
favor of the plaintiff,
8/9/2014, my lord.
in favor of the plaintiff.
Yes.
You sure?
Then, my lord, title appeal number 12/2015 was filed. And the delay was not condoned.
Delay was not condoned.
Yes, my lord. But whatever is observed by him, my lord, my lord, for the time being, let him come, my lord. Let R.K. Moore come, my lord. I am there for the other case, I cannot go there.
Arkemo is this side.
Yes, my lord, yes, my lord,
Where do you need him?
yes. He is along with me, my lord.
Understood, but this side is not there.
This side is not there, yes.
So I dismiss the matter for default.
Okay.
Then I can't proceed on merits. None appears on behalf of the appellant on call. Mr. A. Sattar appears on behalf of the respondents. Who stop taking into account the above, the instant appeal stands dismissed for non-default. Full stop. The records be returned after 90 days from the date of the instant order.
11,
Yes,
My lord, very frankly, I should dispute. to
taking
your
into
lordship.
account the smile of Mr. R. Ali, it seems you have lost in both courts.
No, my lord. My lord, actually, I should say frankly, my lord, before your lordship, that they are in bona fide need of the premises. That is there, my lord. And as per your lordship's observation in one of my case, about 2025 Supreme Court 913, that case, my lord, kindly give me 6 months' time, I will vacate.
Which one? 2025? Oh, that one.
Yes, my lord.
That you have,
That-
have you taken any steps for this?
Yes,
Isn't it?
yes, that is.
As to whether you have taken any steps for, this is a very interesting development of law.
Yes, my lord.
Now, because of that judgment, now they have also to plead in every stage. Because the word used out there in that judgment by Justice Vishwanathan
Yes, my lord.
is to the effect that they have also to say why in that this is, they have now made it in a form of a balance of convenience.
Very good.
So if a person concerned does not show that he had tried to find any other place but could not, meaning thereby the all earlier judgments where it says that the bona fide requirement burden lies upon the landlord is being tinkered with it.
Yes, yes, yes. Apart from this, my lord, actually, I was not aware of this judgment, but your lordship had quoted it from your lordship's side. And when I have obtained that copy, I have found that, no, the bona fide requirement is the pressing need of the land. I have made the process easy for Rubul.
The process is easier, but it is not easier for me. I have to then also write that order. Huh?
Yeah, then,
Unless you come to a settlement before the court to that effect. Okay, you are going to do so. File an affidavit. I'll then allow you 6 months.
Maybe reduce 3 months.
What?
Condition is very pathetic on the part of the landlord side.
Chalo.
Two younger son
I don't
remain
want,
unemployed.
Mr. Counsel, then I would not take up the matter today
Look,
and say that, okay, least the matter after 2 weeks. Then it will come after 6 months automatically. Then you get another 3 months. Would you like that? Huh? More
I will try to-
reasonable.
I will file the affidavit, my lord, as directed.
Okay, then let me dispose of. Today I've got so many matters have been dismissed for default, let me pass something on merits.
Then, my lord, the shoot was, my lord. It
Is
was,
the plain,
the plaint, your lordship will be pleased to see at page number 12.
affidavit in opposition
It-
is
it
being
was
also
not
filed.
filed
What
by
is
the-
wrong with you? Why are you filing affidavit in opposition?
But the cross-examination was in Assamese, that's why
Huh?
cross-examination was recorded in Assamese. That's why to bring all those cross-examination. I filed an affidavit in opposition.
Oh, there is a counterclaim.
There is a counterclaim, yes.
The counterclaim is allowed.
Counterclaim was allowed by the appellate court, my lord, not by the learned trial court.
Okay. On the ground of bona fide.
Bonafide.
Let us see therefore the first appellate court judgment.
First appellate court judgment, your lordship will be pleased to file at page number 31. Sorry.
Page
23/4/2018, page number 51 to 70, my lord. First appellate court judgment.
Lordship will find effective but from paragraph 12, internal para, page 65.
Plaintiff to the supremacy on going from mother to the
Page 55.
Okay, interesting is madam, your matter have allowed it. Transfer petition. You are waiting for the transfer petition?
Yes, Lordship.
That I have allowed it. On 11th of July, you file your written statement at Silchar, na, you want? Silchar. I take it on Nam to Bhoradi. I said none appears, then also I allowed it. But you are there.
Arrow key lenge.
So your case is you asked for 5 years in 2015
Yes, my lord, yes, my lord.
and 5 years is over.
Is over, my lord.
And you have taken the 5 years into 10 years.
Eh, My lord, that's why I'm saying only 6 months' time may be allowed.
I can cut it short then because that is your plea in your.
Instead of arguing the matter before your lordship, the facts and circumstances, kindly allow me, as per your lordship.
ठीक है.
Gracious.
Heard Mr. A. Sattar, the learned counsel appearing on behalf of the petitioner. And Mr. R. Ali, who appears on behalf of the respondents, petitioners, na? Petitioners,
Respondent defendant.
you are one,
No, I am, my lord, plaintiff, because I being the tenant.
you are the petitioner,
I am the petitioner.
one
before you.
petitioner,
Yes,
you are for the respondents,
all three.
Respondents, counterclaimants.
respondents.
Respondent, all respondents.
Respondents. Pusto. The present proceedings have been filed by invoking the revisional jurisdiction of this courts under section 115 of the Code of Civil Procedure 1908, for short the code, challenging the judgment and decree dated 23/4/2018, whereby the appeal filed by the respondents herein was allowed, thereby passing a decree for eviction against the petitioner herein. Pusto. For appreciating a pusto. At the outset, taking into account the revision, at the outset, taking into account that the revisional jurisdiction of this court have been invoked, let this court therefore take note of the provisions of law, the scope of the, say, jurisdiction. A paragraph number 3 and 4 बोलिया था judgment था सही बोल दिया से तो खुद में बोला 3, 4, 5, 3, 4 types of 5 है 6 इतिहास 6 facts. The materials on record show that the respondent herein, the petitioner herein as plaintiff, had filed a suit being titled suit number 46/2015 before the learned court of the Munsip at Nalbari against the respondent herein, who were the defendants.
Number 1, sir.
Number 1, Nalbari. The said suit was registered and numbered as title suit number 46/2015. The case set out by the plaintiff was that the predecessor in interest of the defendants had entered into an agreement with the plaintiff in respect to the suit premises, which have been more specifically described in the Schedule A to the plaint. On have entered the predecessor interest of the plaintiffs have of the plaintiff as well as the predecessor in that. This is the specific case of the plaintiffs that the predecessor in interest of the defendants had entered into a tenancy agreement with the plaintiff with effect in respect to the suit premises as described in Schedule A to the plaint with effect from 1/1/1996. Subsequent thereto, after expiry of the said period, time and again, the rent agreement was extended along with the rent being increased. First, it is the case of the plaintiff that on 11/4/2015 at around 10:15 p.m., the defendants, accompanied by some persons, came to the suit premises and asked the plaintiff to vacate the premises on or before 30/4/2015, failing which the defendants threatened the plaintiff. Subsequent thereto, the plaintiffs also received a notice issued by one Rishikesh Sarkar advocate asking the plaintiff to vacate the house suit premises on or before 31/3/2015. The subsequent note, it is also mentioned that prior thereto, the plaintiff also received the notice from one Rishikesh Sarkar advocate asking the plaintiff to vacate the suit premises on or before 31/3/2015. First, the plaintiff submitted a reply to the said notice stating inter alia that he required another 5 years' time to find a suitable place. Also informed that in course of the business, the plaintiff has to realize 25 lakhs from different customers. First, the plaintiff, fearing that the defendants would dispossess the plaintiff without following the due process, instituted the said suit seeking various declarations to the effect that the plaintiff is a lawful tenant under the defendants and the plaintiff should not be evicted without full due process of law. Along with the declaration, the plaintiff also prayed for a permanent injunction. Upon summons being issued, the defendants jointly filed a written statement raising various preliminary objections, also denied to various averments made in the plaint. It was the case of the defendants that it was the specific case of the defendants that the earlier landlady, late Madhavi Deka, was the wife of the defendant number 1 and the mother of the other defendants. After the death of late Madhavi Deka, the defendants became the landlords of the suit premises by way of inheritance. The defendant number 1 ran a medical store in the name and style of Deka Pharmacy in a rented house at PNC Road near Thana Chowk, Nalbari town. The rents collected from the suit premises and the earnings from the business of the defendant were the income source of the family. The defendant number 1 sustained grievous injury in an accident on 17/4/2002 and became partially paralyzed. The defendant number 2, after obtaining license from the concerned authority, took charge of the pharmacy and otherwise unemployed defendant number 3 helped in the family business. It is the further case of the plaintiff that till the landlord of the pharmacy took over the possession of the pharmacy room for his own use 3 years back, the defendants did not have any difficulty. However, without the pharmacy, which was one of the source of their income, it became difficult on the part of the defendants to sustain. And as such, there was a necessity, there was a bona fide need of the suit premises so that the plaintiffs, the defendants could carry out the business of pharmacy. Full stop. It was further mentioned that it is under such circumstances a notice was issued to the plaintiff to vacate after the expiry of the period of tenancy, that is 12/9/2014. Tenancy, that is
It was, my lord, up to 31/3/2015. 31/3/2015 was the last.
31/3/2015.
Yes, my lord.
However, the defendant, a plaintiff, submitted a reply that he required another 5 years and 5 years. And it is under such circumstances, the counterclaim was filed seeking eviction of the defendant from the plaintiff from the suit premises. It is seen that on the basis of the pleadings, the learned trial court framed
10 issues, man.
10 issues which are reproduced herein under page 60 and 61. On behalf of the plaintiff, 3 witnesses were examined and 6 documents were exhibited. On behalf of the defendant, 3 witnesses were examined and 9 documents were 3 witnesses were examined and 9 documents were exhibited. First, the learned trial court provided judgment and decree dated
16/8/2017, my lord.
16,
16/8/2017.
page.
That is, my lord, page 5 to 3.
By the judgment and decree dated
31.
Page 31, no? Yes,
16/8/2017,
70.
decreed the suit in favor of the plaintiff and dismissed the counterclaim. Full stop. Being aggrieved, the defendants preferred an appeal, which was registered and numbered as title appeal number 21/17. And the learned trial court, a first appellate court, that is the court of the civil judge Nolbury, dismissed the suit and decreed the counterclaim, isn't it?
Yes, my lord.
And it is under such circumstances the present proceedings have been initiated. First, the issue involved in the present proceedings, taking into account the issues framed in the suit, the point for determination involved in the present proceedings in view of the issues being framed and the discussions and the findings arrived at both by the learned trial court as well as the learned first appellate court appears to be the question as to whether the defendants had bona fide requirement of the suit premises. This court at the outset finds it very pertinent to take note of that in the notice so issued by the plaintiff, by the defendants, asking the plaintiff to vacate by 31/3/2015, it was categorically stated, it was categorically mentioned as to why the defendants had bona fide requirement of the suit premises. It was categorically stated that the defendants had a requirement of the suit premises. In reply, which is an admitted fact as would be seen from the pleadings of the plaintiff, that the plaintiff sought for a period of 5 years in the year 2015 so that he can find a suitable location for shifting his business. As on date, when the present proceedings is being taken up, it has been 10 years since the date on which such notice reply was issued, meaning thereby that the plaintiff, meaning thereby that the period which was sought by the plaintiff for vacating, which is an admitted case of the plaintiff itself, have long passed. This court further finds the findings arrived at by the learned first appellate court, wherein duly taking into consideration that the plaintiff's defendants had bona fide requirement of the suit premises, had arrived at the finding that the counterclaim was required to be decreed in favor of the defendants. Consequently, as there is no perversity in the findings of the learned first appellate court in its judgment and decree dated 23/4/2018, passed entitled Appeal number 21/2017, the question of interference with in exercise of the revisional jurisdiction of this court does not arise. Next. While dictating the judgment, Mr. ex-parte, the learned counsel, appearing on behalf of the appellants, appearing on behalf of the petitioner, submitted that some time may be granted to the petitioner to look for to make a suitable arrangement for taking into account that the plaintiff, the petitioner plaintiff have been running his business since 1996 in the same suit premises. Mr. orally, the learned counsel appearing on behalf of the respondent submitted that the petitioners, the respondents herein, who are the defendants, have been suffering since 2015. And on account of a want of a suitable place for carrying out its business. Therefore, therefore, no further time may be granted. First, undertaking he has to give within 6 months to the undertaking the executory
27.
27 na. He has to file the undertaking by 6th of June before the learned trial court. You have not filed execution, na?
No, Lord.
Within 6th of June, he has to submit the undertaking along with what is recorded. Mr. Sattar knows, he has given many of these undertakings. And so these details will be there. And thereupon, if he fails, then you can go ahead with the execution. And during this period, nothing to be done, and he will be making certain payment in the form of compensation.
My lord, that 10,000 rupees I am paying, man.
Now, what is the compensation now he's paying to you? How much?
Lordship, that prior is not specifically there, but as per information, MJ cases is filing in every month.
How much you are paying?
10,000 per month. 10,000 per month.
Now to NJ case, you can't file.
No, now I won't file.
You know, you cannot file also
Yes,
because I have terminated the landlord tenant.
Yes.
So now you have to file, you have to pay 10,000 to him.
Yes.
But this would not create any landlord tenant relationship.
No, my lord. 6
That-
months, my lord.
6 months.
Right, my
And
lord.
not 6 months, date is given.
No, that
Date
for the
27.
file.
1, 2, 3, 4. By you will vacate on or before 27th of November 2025. 27 November 2025. On or
And by 6th of June, I will file the affidavit.
by 6th of year before the trial court.
Yes, ma'am. Oblige your lordship.
Because there I have mentioned that this undertaking shall have the force of law.
Oblige.
Yes.
Lordship, I'm sorry, in item that we could not remain present, Lordship. In fact, we,
Dismiss for default.
Lordship, can it be upgraded at 2, Lordship?
No.
I'm ready to. argue
Dismiss
this
for
one.
default. Cost of 15,000. If you pay by then and show a receipt.
Cost I will pay, Lordship, but if it, Lordship, can we take up the matter at 2 PM, Lordship?
Mr. Sattar is there on the other side. You have objection if I take it up at 2?
That, my lord, let it be on some other day, my lord. Let it be on some other day.
Then
my lord.
50,000 cost.
Cost I will pay from my pocket, Lordship. There is no, but Lordship may take up this item, Lordship.
Well, her point is 2 points. First is on the condonation.
Yes.
And the second point is as regards
Legal error of Lordship.
legal hair of that person's concern was there. So something she could have got it.
Lordship.
Some 10 lessons of 1 katha.
At 2
That is
points.
it. Well, we'll take it up at 2. But we'll impose a cost.
Lordship, there
If I allow the video.
is a similar period in item number 8, Lordship. Lordship, only difficulty is that we.
Both of you first deposit 15,000 and 15,000 before the court, before the registry, and thereupon we will take it up at 2.
Only thing is that we have already written to our clients, Lordship. We have not been able to establish any contact with them for the last 10 years.
Which one?
Item number 8. Lordship has indicated that we have not taken steps with regard to the substitution of the legal heir or respondent. So we have already written to the,
I've said that. You have not taken steps and this, so I've dismissed.
only that data which I have sent to my client, that be a part of the. record.
No. You were not present, none appears.
Lordship, observe only that.
I cannot do that. I'm not going to look there. You deposit 15,000, then I'll take.
already written to our client that due to.
You have not appeared. Matter over. If you argue on merits, then you can.
I cannot because I have already expressed my unwillingness to represent
Then none appears.
only my name image.
None appears. I've said none appears. So this will, one day they will come. And your is 15,000. And if I allow the appeal, then the appeal is allowed without cost. And if I dismiss, now I've increased it to 35 plus 15, 50.
I will add to I have a copy of the letter, Lordship, I have written to my client.
Yes. What do you want?
My lord, in both the appeals, the substantial cost of law involves only as regards section 5 of the limitation act regarding sufficient causes shown. The footland, my lord, is a part of land of about 2,000 bighas in a single Dagen Patta, in which we the defendant as well as the plaintiff have got their due shares. This has not yet been separated by any partition suit. In Elmani, they are trying, but they are trying to get the specific position over land, affecting about 40 bighas of land to us in both the appeals. So my submission is that the first appellate court did not hear the case on merit only on the basis of the application under Section 5 of the Limitation Act, the same way are rejected. And so there is, after the trial court's judgment, there is no adjudication of the issues, real issues involved in the suit matter. That's why I preferred the second appeal against the order for rejecting the order for coronation of delay. The delay was 326 days, in which also there was the COVID-19. Immediately before, after the judgment, my lord, the original defendant died, and thereafter his successors, the present appellant, entered into affairs, and they handed over the original file to one person to file an appeal before the High Court. At that time, the jurisdictional court was High Court regarding first appeal, but subsequently it was found that the jurisdictional court was the district court. So the file was returned, and we filed the condemnation application as well as the appeal, which was rejected. I felt that even by imposing a heavy cost, my lord, or us, they might be condemned.
And what are these missed cases for?
These cases are for, my lord, for amendment of the written statement at the appellate stage. These are the, if the appeal is, before it was heard, the missed cases were filed for amendment of the written statement. In the written statement, it was not specific and no counterclaim was done, and this has been necessitated because after the degree, the circle officer issued some notices in invoking some more than 18 persons around the land. Since the land is a national land, so by invoking the other persons, these were not in the plain value. So the amendment is necessitated. And as your lordship knows, amendment can be allowed at the appellate stage also, at any stage of this.
So the appeals have been admitted.
Appellate has been
by
granted.
Formulating substantial question of law.
Yes,
Yes, my lord, admitted.
So now you want amendment.
amendment of the written statement regarding the submitting a
In the
decision.
last occasion, your lordship has
of
gone
the
to
Supreme.
the substantial question of law, to law, and your lordship has observed that these are not the substantial question of law. So may I
Regarding in this case,
draw your
no,
lordship
no order has yet
attention
been
to the
passed.
substantial question of law?
This is regarding appellant amendment of the written statement.
These cannot be substantial questions of law.
Under the sufficient cause. If there was sufficient cause in submitting the application. And my lord, the first appellate court did not enter into the merits of the case. Purely on sufficient cause. we rejected.
Now you are seeking amendment of the written statement.
Yes, sir. In this case.
Okay. Now in this petition, where you are seeking amendment of the written statement, what is the schedule of amendment? 23M, the plaintiff has based his claim on the basis of purchase from so and so in respect of so and so. The defendant request state.
Schedule of amendment is at page 7.
Now, why you could not file this amendment application earlier?
Because I was not there. My father was there,
What?
but he did not file. And now it is necessary.
No, Mr. Counsel.
Yes, sir.
Why you could not file your amendment written statement
Yes.
of the written statement prior to the trial has
Because
begun?
it was only very recently the order was passed.
Huh?
The notice was issued very recently on at page 30, my lord. 29 of
Page?
this case. These new persons have been brought in.
No, where is your justification?
Yes,
Why you could not file the amendment to the written statement at the time when the suit was pending?
Yes, sir. Because it was subsequent development.
Which subsequent judgment?
This notice has been issued very recently as in page number 29. Well,
What notice?
notice was given by notice for demarcation. Annexure 5 at page 28 of the case. All these persons in the boundary were brought in.
So how is this notice have any relevance?
Because my lord, since there is no demarcation of the plot of land, 2000 began. Now it is all determinable only by this boundaryment. And boundaryment have been changed, not in the plan. The boundaryment, 18 persons have been brought in. If the land was partitioned, there was no question mark. This is different from the plain plan. and this is necessitated. It is only 7/12/2022 notice of issue.
You are the defendant.
I was the defendant. I must incorporate these persons in my written statement.
There is a sale deed made by the defendant number one in your favor.
Yes.
So the defendant number one takes a plea. Then look here, I did not have the saleable right.
Yeah.
Because I have already sold off these lands to others. Isn't it the case?
Yes, my lord. My lord,
That is issue number 4.
my lord, the second appeal is only on the delay ground. Second appeal is filed on the dismissal of the first appeal on delay ground. So,
No,
delay,
I understand, Mr. Counsel. You see, I'm going to otherwise dismiss the appeal on these two questions, but I'm just looking into it as to whether there is a substantial question of law involved.
yes,
So the question is, the finding of fact, they did not adduce any evidence to the effect that they have sold off, that a defendant number one sold off this. It could be seen from Exhibit 7 that it was being sold by somebody else and not by Akram Ali. This, what you call the defendant number one, Akmol Ali. And did your Exhibit 1 had a boundary? Did exhibit one have a boundary?
Yes, but cell did. 27-221 and 30-12-69. Yes.
North, south, east, west?
Same.
Exhibit one.
Seven to two.
Okay. Now, the decree which has been passed is declaration of right title interest of the plaintiff over Schedule 1 and to have a survey over the suit land under Schedule 1 by the competent government authority to get demarcation of the total 20 bighas of land, including 3 kata of land under Schedule 1A, and to get possession over the same if the plaintiff is illegally dispossessed. Isn't it?
Yes.
So, the trial court Mr.
Yes.
These two petitions are required to be dismissed. Ayes.
Yeah, peer.
The question of amendment does not arise because this is subsequent to the direct decree being passed.
Yes.
And how does it have relevance?
Only after filing of the present appeals, he says.
Understood. This is a consequence because there was execution proceedings filed.
Yes.
So therefore, they have gone for a survey.
Brought in some other persons who were not the original parties or the bound limit.
How is it relevant? You are not, are you not appearing for these heirs of Akmal Ali?
No, from foreign of the sons and daughters of Aftabuddin.
Huh?
I Aftabuddin. Akmal Ali was my father who died.
So that is for them only you are appearing.
Yes.
So your father
Yes.
have sold by exhibit 1
Yes.
20 bighas of land to the plaintiff.
Yes.
Your case
But
is
my land is separately purchased land.
understood.
Yes.
But the fact that you have sold the land is not in dispute. But the question is, you
My
did
plea
not,
was that my father did not have the title about those that because he has already exhausted his title.
but did you prove any document to show that it was exhausted?
I did not.
Then
But that's why I filed this first appeal. In the first appeal court, if it would have been adjudicated upon
how?
by bringing those records.
So you did not exhibit those documents.
No.
So under such circumstances,
Yes.
the fact that you have sold 1 bigha of 20 bighas of land is there.
Yes.
You could not prove it.
Yes.
That you the land of Akmal Ali had no right to sell it. You could not prove it.
I would.
Because it is you who had to prove it.
Yes.
Taking into account that Akmal Ali and 2 others have purchased 339 bighas of land. And the court categorically comes to an opinion after perusing Exhibit 7, that to the effect that from there it appears that these lands were actually sold by some Akramali. Who is Akramali?
Another person.
Another person. So this is not being sold by Akmal Ali. So therefore the court holds that this is there. Now the question is, the court further directs issuance of a Amin Commission. And the Amin Commission will identify the 20 bighas of land. And while identifying the 20 bighas of land, if it is found that they are in dispossess, he shall be
Given the product.
possession.
My lord,
Only
that-
in
that
respect
order
of
was
3.
Earlier challenged before this honorable court, my lord, that
Which one?
this execution, commission's order in the executing court, that was challenged before the honorable court, but this was suppressed, my lord. And this honorable court, I have annexed the order, my lord. Dismiss the, my lord.
No, therefore, what he is trying to, by bringing into this amendment,
Yes.
is absolutely that these type of amendments cannot be allowed, taking into account this has happened subsequently.
After the
Subsequently, this is a thing which has happened in the execution proceedings, which has nothing to do with the cause of action for the suit. So your applications for amendments have to be rejected. First, let us reject those. And what are 2 applications?
Two appeals are
two
there.
suits.
Huh?
Two appeals are there.
2 appeals are there.
2 suits.
148 and 149.
Okay. Lahok. Heard Mr. N.H. Madal Bhuiyan, the learned counsel appearing on behalf of the applicants, and Mr.
MJ Kadir.
M.J.
Kadir.
So and so. The learned M.J. Kadir, the learned counsel appearing on behalf of the respondents,
Yes.
opposite parties.
Sole respondent.
On behalf of the respondent, Fusto. This is an application filed under Order 6, Rule 17 of the Code of Civil Procedure, seeking amendment of the written statement filed by the petitioner applicants who were the defendants in the suit. Defendants in title suit number 4/2016. Who were some of the defendants. These were who were the defendants. What was there? Because there are 2 for the same suit.
Different suit, 2 suits. 2 suits.
2 suits.
2 appeal, 2 suits.
Okay, this is for which one? I'm taking up 13148.
RSA 149.
Huh?
RSA 149.
148. 148, what is the suit number? In seeking amendment of the written statement in title suit number 4 filed by the applicants who were the defendants in title suit number 4/2016. Full stop. This court have duly perused the said application and the reasons so assigned in the said application why the amendment is being sought for. Full stop. From a perusal of the said application, it appears that, full stop. Full stop. At this stage, this court finds it relevant to take note of that the learned trial court, by the judgment and decree dated 28/2/2020, had decreed the suit in favor of the plaintiff, the respondent herein, by declaring his right, title, and interest over the Schedule Roman 1 land, and to have survey over the suit land under Schedule 1 by the competent government authority to get demarcation of the 20 bighas of land, including 3 kata, KATA of land under Schedule 1 bracket capital A to get possession over the same, and if found that the plaintiff is illegally dispossessed. Full stop. It is relevant to take note of that pursuant to the said judgment and decree dated 28/2/2020, passed in title suit number 4/2016, an execution proceedings was initiated by the plaintiff, which was registered and numbered as execution case number. What is the number?
Eight of 2020, madam. 8 of 2020.
8/2020, before the court of
Civil
the
judge,
uh,
civil judge Hailakandi,
civil judge senior division
Hailakandi,
Hailakandi. Sribhumi, no, Hailakandi, na?
Hailakandi.
Hailakandi. Full stop. Pursuant thereto, pursuant to the said execution proceedings being filed, and steps being taken therein, a notice was issued by the Assistant Settlement Officer, Algapur Revenue Circle, on 7/12/2022. First, on the basis of the issuance of the said notice, the applicants herein seek amendment of the written statement which was filed in title suit number 4/2016. Full stop. In the opinion of this court, the reason for which the amendment of the written statement has been sought for cannot be permitted, taking into account that the cause of action on the basis of which the suit was filed, taking into account that on the basis of steps being taken in an execution proceedings, comma, the no question arises for amendment of the written statement full stop. Consequently, the instant application stands dismissed. The other is which suit? Same date notice, na?
Same day, same day.
Other is, what is the title suit number?
There is one is 4 and one is 3.
3. You can dismiss. Now let us take the appeal.
Execution and another case 7. One is 7 and one is 8. Execution.
You give your dates, huh?
Okay.
I silent book one. And it is this order of this is mentioned in both cases 4. So suit number and execution number, huh?
Okay.
And along with the respective miscase.
Okay.
Okay. Now let us take up this appeal. Judgment and decree passed on
22/2020.
28 huh?
28/2/2020.
28/2/2020.
2020.
In both cases.
Both cases.
Entire this is where let us first take up RSA 148. RSA 148. 148. Oblique 2023. 28/2/2020, This is in connection with title suit number 4. Huh? Four. Oblique 2016. Judgment and decree passed on 28/2/2000. When was the appeal filed?
B1 2023.
P1 2023. Okay. Now, he gets the limitation benefit from 15/3/2020 to 3 months from 12/28/2. He gets benefit from 15/3/2020.
To-
Okay.
To 14/3/21.
To, huh?
14/3/2021.
14.
14/3/2021.
14, time from 15/3, he gets benefit till 3 months. Appeal is for 1 month. What is the order being passed on 12th of January?
1 month, the first appellate. First appellate 1 month.
What is the order passed on under section that Supreme Court judgment for filing in the period has been given the exemption? 12/1/2022, there is an order. Where is that? To 28/2/2022. He gets an exemption. No, I think 1 month thereafter, na?
First appellate 1 month. First
No.
appellate limitation 1 month.
Where do I get that order? Anybody has that order? You have not come prepared, Mr. Madhav.
Yes.
Then where is that order? That is your case.
First appellate court order is 10/8/2023.
Huh?
First appellate court's order is 10/8/2023.
I'm not concerned with first appellate courts. I'm only, you see your two substantial questions of law being framed. That is the only thing which I'm looking into it. Where is that order of 10/2?
Original case you got. The original case you got the coordination order is there.
Problem is you don't have. Where is that order of 12/1/2022? Is the order passed by the Supreme Court? Got that order? This one. So the judgment was passed on Iman. So for 15 days, 14 days will go there and 16 days. So he had to file the appeal by 16, period was extended by to 16/3/2022. Isn't it?
Yes, 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 ma'am.
Now he filed it on 3/1/2023. Okay. So the delay was 326 days.
Yes.
Now, in both cases.
Both cases.
Okay. Now, what is the ground assigned? Where is the application seeking condonation of delay anywhere there? The petition is not here. So it says brief was handed over to the advocate on March 2021 and he returned it on where is the application? Means super title equivalence. Let us see the reasons. You are framing questions of law on the basis of the application under section 5 and you have not enclosed the section 5. Yes, got it. Huh? What is the number of the case? Miss case?
It is 11 of 2023.
Now, what is the miss case number? 9/2023. It won't go to. Till appeal 02. Miss case number. Huh? Nine. Okay. Okay. The appellant petitioner has filed an appeal against the order dated demand passed by in Miss case number 62. Petition. Miss case number 9.
In 148, it is Miss J 9 of 23.
Got it. No good reason. Who passed the judgment?
Additional stages.
Who is the trial court?
Trial court is civil judge, madam. Civil judge.
Senior division.
Only civil judge, madam. There is
Huh?
Civil judge, senior division.
Are you not in a position to tell me who is the civil trial court?
civil judge. Only civil judge is mentioned. Only civil judge is mentioned, madam.
Senior division or junior division?
Actually, senior division.
In the Hailakandi, my lord, is only mentioned civil and munsif, madam.
So Munsif is always the junior division. Senior division. And what was the value of the suit? You are a plaintiff, you don't know.
I believe 10 lakh, 10 lakh, 10 lakh.
10 lakhs. And when did the jurisdiction change here?
In the year 2021.
21, madam. During that period, during that period, madam. After passing the judgment, madam. During that period.
Now, when did the jurisdiction change out here? When there was the amendment by which it was made less than 10 lakhs, will go to the district court.
May I submit? I have undergone some treatment in Bellumal. If petition they came.
Who?
I myself made. Because there is a stroke, madam, for me. So it may be taken up some other day, I should have to.
No, I've spent too much of time in this matter now. Take your seat now.
2021,
Huh?
2021. As per the Bengal, Agra and Assam Civil Code, Assam Amendment Act 2021.
What happened? Date of enforcement of that?
Notification dated 24/9/2021. 24/9/2020.
24/9/2021. Now, what is the value?
Value is now
Value of the district judge. There you will find there.
yes.
Hare? Yes, madam, kindly see and tell me. So this changed from 10 lakhs. Huh? Junior division. No, who passed the decree? Senior division passed the decree. No, they preferred the appeal later on before the district judge. Let us see what is the valuation of the suit. Valuation of the suit is taken as 10 lakhs. It is valued at 10 lakhs. And both the suits.
Both the sources.
Mr. Kadir, I think you also need to file an appeal. Trial court. Or cross objection. Because once they file it, you file a cross objection. I think this delay needs to be condoned. What has happened, you see, you have sought for declaration of right title and possession of the plaintiff over the Schedule 1 land on the strength of purchase. For eviction of the defendants and agents from Schedule 1A land mentioned in the plaint. Award of rupees 2,50,000 granting a perpetual injunction. Okay. Now what has happened? The trial court, decree is being passed, declared your right title and interest, and went for a survey. This survey question should have decided at the prime of when the trial was there. Don't you think so?
Against this survey order, there was a civil revision petition before the.
I'm not on. Kindly understand.
Yes.
Against the survey, Once the survey is being done, who is going to hand over the possession? So the survey should have been done prior to the suit being decreed. Okay. Now you have asked for compensation. Nothing has been granted. So under such circumstances, don't you think that you need to file a cross objection under Order 41 Rule 22? Isn't it? So the best way is allowing his appeal, remanding the appeal back to the first appellate court. Then once the appeal is admitted, date will be fixed for hearing. You file Order 41 Rule 22.
Regarding this delay, my lord, whether delay is sufficiently explained that
Don't worry, that I will take care of. He has not said, although he has not said that. But at the end of the day, you are at loss. Now, how can you get this? You have asked for 3 katas of land. So the court have not come to a finding as to whether you have been dispossessed or not. The trial court's decree couldn't have been like that. The trial court's decree should have been for recovery of possession. This commissioner's appointment should have been prior to that. Don't you think that? Heard Mr. N.H. Madhavbhaiya, the learned counsel appearing on behalf of the appellant, Mr.
MJ Kadir.
M.J. Kadir, who appears on behalf of the respondent. Full stop. The present, the instant appeal is filed challenging the judgment and decree dated 10/8/2023 passed by challenging the order dated 10/8/2023. Now, this is an appeal under Section 100 of the Code of Civil Procedure, challenging the order dated 10/8/2023 in Mizze case number 9/2023, arising out of title appeal number 02/2023 by the learned court of the additional district judge, Hailakandi, hereinafter referred to as the First Appellate Court, learned First Appellate Court, whereby the application filed under Section 5 of the Limitation Act 1963, read with Order 41 Rule 3A of the Code of Civil Procedure 1908, for short the code, was rejected, and thereby confirming the judgment and decree passed by the judgment and decree passed by the learned trial court dated 28/2/2020 entitled suit number 4/2016. It is taken note of that by an order dated 31/8/2023, 2 substantial questions of law were formulated by the learned coordinate bench of this court, which reads as under. The question arises as to whether the 2 substantial questions of law are at all involved in the instant appeal. Full stop. From a perusal of the above 2 substantial questions, Mr. N.H. Madhavbhaiya as well as Mr. M.J. Kadir, the learned counsel for the appellants, and Mr. M.J. Kadir, the learned counsel appearing on behalf of the respondents, submits that both the substantial questions of law are in fact one and the same, taking into account as to whether there was an error in exercise, whether the jurisdiction so exercised by the learned first appellate court under Section 5, while deciding an application under Section 5, was in accordance with law and by taking into account the various settled principles of law. Full stop. Taking into account the above, the question therefore arises as to whether the said substantial question of law so formulated by the learned coordinate bench of this court dated 31/8/2023 is involved in the instant appeal. It is seen that the learned trial court, that is the court of the civil judge, senior division at Hailakandi, it is relevant to take note of that the suit so filed by the respondent herein as plaintiff was valued at rupees 10 lakhs. Full stop. The said suit was filed before the court of the civil judge, senior division, Hailakandi. Full stop. By the judgment and decree dated 28/2/2022, the learned trial court decreed the suit in favor of the plaintiff. Full stop. The relevant portion the order passed in the said suit being at paragraph number 43 being relevant is reproduced herein under page 62. It is relevant to take note of that the period of limitation for filing an appeal against a judgment and decree passed by the learned trial court to limitation act in terms with Article 113. What is the limitation act? 113? It is relevant to take note of that in terms with Article 116 of the Schedule to the Limitation Act 1963, an appeal against a judgment, against a decree or order to the High Court is 90 days from the date of the decree or order, and to any other court 30 days from the date of the decree and order. Full stop. Taking into account the said judgment, taking into account the said provision, the period of limitation for filing the appeal would be 30 days in the case the appeal was preferred before the learned district judge, Hailakandi, and 90 days if it was preferred before the High Court, before this court. It is further taken note of that during this period, on account of the COVID pandemic, the Honorable Supreme Court had passed various orders, thereby extending the period of limitation. The order of the Supreme Court dated 10th of January 2022 in Sumoto writ petition number 3/2020 is relevant for that purpose, in as much as it is stipulated therein that the period from 15/3/2020 till 28/2/2022 shall be excluded for the purpose of limitation. Full stop. Under such circumstances, the appellants herein could have preferred the appeal before this court on within 16/5/2022 and before the learned district judge Hailagandi within 16/3/2022. It has been alleged by the plaintiffs, by the appellants, and it is seen in that respect, it is very pertinent to take note of that the appellants had stated that they had handed over the brief for preparation of an appeal in the month of March to one Mohammad Mehboob Hussain Majumdar Sozol, advocate of the Silchar Bar Association, to file an appeal before this court. And he had undertaken to do the same. However, in the month of November 2022, the said advocate informed the appellants that the jurisdictional code for filing the appeal has been changed from the High Court to the court of the district judge in view of the amendment to the Assam Agra Civil Courts Act 1887. And accordingly, he returned the brief on 16/12/2022. And thereupon, the appellants preferred the appeal on 3/1/2023. Full stop. This court further takes note of that it is a well-settled principle of law that the jurisdiction under Section 5, that the court, while exercising the jurisdiction under Section 5 of the Limitation Act, has to exercise the jurisdiction liberally full stop. Taking into account that the delay in preferring the appeal is primarily on account of the mistaken advice given by the advocate, it is the opinion of this court that the learned First Appellate Court ought to have condoned the delay in preferring the appeal against the judgment and decree dated 28/2/2024, 28/2000. First stop. Accordingly, it is therefore the opinion of this court that the two substantial questions of law so formulated by the learned condemned bench of this court are duly involved in the instant appeal. First, accordingly, the appeal stands allowed, thereby interfering with the order dated 10/8/2023 in Ms. case number 09/2023 arising out of title suit appeal number 02/2023. First, next, this court further duly takes note of that the two substantial questions of law only pertains to the order dated 10/8/2023 passed in Ms. case number 9/2023 and has no relevant reference to the decision on merits passed of the learned First Appellate Court, of the learned trial court on decision on merits in respect to the judgment and decree dated 28/2/2020 passed by the learned trial court. Considering the above, as this court had interfered with the order dated 10/8/2023, passed in Mizze case number 09/2023, the appeal, this court condones the delay and restores the appeal being titled appeal number 02/2023 to the file of the learned additional district judge Hailakandi and remands the matter back to the learned additional district judge Hailakandi for decision of the said appeal on merits after admitting the same a decision on of the appeal on merits. Full stop. Accordingly, the instant appeal stands disposed of. This court further, taking into account that the appeal is being remanded back to the learned first appellate court, the matter is remanded back to the learned first appellate court, that is the court of the additional district judge Hailakandi, to decide the title appeal number 02 TA number appeal number 02/2023 on merits, this court further, in exercise of the powers under Order 41 Rule 26, directs both the parties to appear before the learned first appellate court on 7th of July 2025. The registry shall ensure that the records, the records of the learned trial court as well as the learned first appellate court are placed before the are returned to the learned first appellate court. Forthwith, ensuring that on the next date so fixed herein above, the records are before the learned trial court, first appellate. We heard same order. Because I think
The other appeal is also there. Other appeal is also there.
other appeal will be same.
I will provide that.
Only,
I will provide that.
only the non-prosecution would be the.
Now,
and
the
number.
thing is, I think this is in your interest, because otherwise your decree you cannot satisfy it. Nothing is going. Because you cannot execute it. And in fact, it should be further remanded again back to the trial court on that issue, because without the Amin Commission should have been prior to that. But this is rejection of the written statements, amendment to the written statement. Or do you want to withdraw?
It may be allowed to withdraw.
It will withdraw correctly. Mr. M.A. Mazhar Bhuiya, the learned counsel appearing on behalf of the appellant submits that applicant submits that taking into account the amendment is being sought at the stage of amendment is being sought in respect to a subsequent event which is in pursuance to the subsequent event pertaining to the learned counsel heard Mr. Swenson, the learned counsel appearing on behalf of the applicant submits that the applicant would not wish to press the instant application seeking amendment of the written statement. Accordingly, the application stands closed on withdrawal. Yes.
So in this case, the appellant is the defendant, Lordship. And this regular second appeal is against that, Lordship. We have preferred one title appeal along with condonation application. That condonation was also rejected and title appeal was also rejected. Against that, this present regular second appeal.
How much was the delay?
Delay, Lordship, that is paid
102 days.
102 days, Lordship. There is an objection filed by the plaintiffs also, and before filing the title appeal, Lordship, already decree was executed and the appellant was ousted from the land. Lordship. A delay petition is page 54, Lordship. Grounds I have assigned in para 4 and 5.
Judgment and decree passed on.
My lord, 8/9/2014.
8/9/2014.
Yes, my
Page
lord.
29, Lordship.
And it was passed ex parte?
No,
In the
Lordship,
No,
contested, contested, Lordship.
contested, 8/9/2014.
We have filed written statement, Lordship.
Then when did you come to know?
Lordship, I have stated in paragraph 4 that on 3/12/14, suddenly the Nazir accompanied by his staff and police personnel went to her residence.
And you filed the appeal on? When did you file the appeal?
January, Lordship.
Huh?
19/1/2015.
19/1/2015.
The same today.
Then you met the lawyer on?
Lordship,
When did you meet the lawyer?
I have recovered on 28/12/14 and met a new counsel at his chamber on the same day who said to her to come to the court on 2/1/15.
1/2025. 2015.
That's because there is an vacation, Lordship, till 1/1/15. And on 2/1/15, I came to know that the decree was already passed on 8/9/14.
When did you apply for the certified copy?
On Lordship 2/1/15, Lordship.
You applied for the certified copy.
Separate copies we have received on 19/1/15.
Where is the order? Where is the order?
My lord, page number 70, my lord.
2/1. 2115 you applied and you got it on 19-1. 17-1 it was ready,
Lordship.
isn't it?
For page 29, it was applied on 5/12/14, Lordship.
What?
The certified copy, which I have annexed, Lordship. Page 29. When she came to know 3/12/14, thereafter she applied, Lordship. 5/12/14. And it gets ready on 17/12/14.
And the decree was separately applied.
Lordship.
So 5/12/14, this is another thing, no? 5/12,
That was applied on 2/1/15.
so you got it on 17/12.
17/1, it gets ready, but I have received the copy on 19/1/15.
No. Page 29. You got the judgment on 17/12.
17/12/14.
So Satar, we will allow the first substantial question of law. Second one, we remand it back.
As you're right. But the decree has already been executed, ma'am.
That is a different thing
yes.
that will come for restitution.
Yes, ma'am.
now. Because then also both the parties would be otherwise missing one chance.
And the first appellate court, we have already taken ground of second substantial question of law.
Huh?
Second substantial question of law, that is a ground taken in the first appeal memo, Lordship.
Appeal memo.
Yes.
Heard Ms. R. Chaudhary, the learned counsel appearing on behalf of the appellant. Mr. A. Sattar, who appears on behalf of the respondents, no?
Yes, madam.
Respondents. This is an appeal preferred under section 100 of the Code of Civil Procedure 1908, challenging the order dated 31/8/2017, passed in where?
Title appeal, Lordship.
Not title appeal, that was in this case.
Miss case number? In petition number
This is
443,
73 years.
dated 30/1/2015, arising out of title appeal number 12/2015, whereby the petition number 443/2015, which was an application filed under section 5 of the Limitation Act 1963, read with Order 41, Rule 3A of the Code of Civil Procedure 1908, was rejected and thereby leading to the dismissal of the appeal, being titled Appeal Number 12 of 2015, and the confirmation of the judgment and decree dated 8/9/2014, entitled suit number 498 of 2010. Full stop. The instant appeal is being taken up at the stage of full stop. It is relevant to take note of that by an order dated 4/12/2017, the coordinate bench of this court had admitted the appeal by formulating two substantial questions of law which reached a done. At the outset, it is being submitted at the bar by both the counsels appearing on behalf of the appellant parties that the second substantial question of law so formulated is a ground of objection which have been already taken, which was taken in title appeal number 12 of 2015. Under such circumstances, the question which arises before this court is as under such circumstances, keeping that in mind, this court would takes up the instant appeal to adjudicate as to whether the two substantial questions of law are involved in the instant appeal. The first substantial question of law, so formulated as stated herein above, pertains to as to whether the first appellate court committed error of law in not considering the grounds stated by the appellant in the condonation application as sufficient ground and rejecting the prayer for condoning the delay in preferring the title appeal. First, it is relevant to take note of that on 8/9/2024, the learned court of the civil judge, Munsif number 3, Kamrup Metro at Guwahati, had decreed the suit being titled suit number 498 of 2010 in favor of the respondents herein who were the plaintiffs.
Yes, madam.
First, it is the case of the appellants, as who can be seen from the application filed for condonation of delay, that she came to learn about the said judgment and decree on 3/12/2014, when the civil Nazir had went for execution of the judgment and decree of the decree, execution of the decree. And thereupon, on 5/12/2014, the certified copy of the said judgment and decree, the judgment, and thereupon the appellant applied the certified copy of the said judgment. First, it is also stated that on account of execution of the decree passed by the learned trial court, the appellant, who is a lady now, widow,
Yes, lordship, unmarried lordship.
unmarried,
Unmarried lady lordship.
age
Age lordship.
at that point of time,
So the memo.
32 years lordship, page 27. Time of filing the written statement, 2011 lordship.
this was further stated that the appellant Appellant or appellants?
Appellant, only one.
One, no?
One.
The appellant. On account of on account of her eviction from the suit room, was compelled to take shelter in a neighboring house. And because of such eviction being carried out, she fell ill. Upon recovery on 28/12/2014, the appellant met a counsel for legal redressal. The counsel informed the appellant that on account of the vacation, the counsel advised the appellant to come on 2/1/2015, as the civil court was to remain in vacation during this winter recess. Accordingly, on 2/1/2015, the appellant engaged the counsel, who thereupon, after obtaining the certified copy on 19/1/2015, filed the appeal. In that process, a delay of 102 days occasioned in filing the appeal, for which an application under Section 5 was filed, seeking condonation of delay. It is also seen that the respondents in the instant appeal, who were also the respondents before the first appellate court, objected to the said application on the ground that the petitioner, that the appellant had knowledge about the judgment and decree, and the reports were submitted by Civil Nazir that he went to the suit room on 7/11/2014 and could not execute the decree without the police help. Clearly goes to show that the appellant had due notice on 7/11/2014, if not earlier. The learned first appellate court, taking into account their objections so taken by the respondents in the said appeal, rejected the said application, disbelieving the case of the appellant, that the appellant came to learn about the judgment and decree only on 3/12/2014, on which date the appellant was evicted from the suit room. The learned first appellate court further disbelieved that the counsel who represented the appellant did not convey, appellant before the learned trial court did not convey about the judgment and decree passed on 8/9/2014, entitled suit number 486 of 498/2010. The learned first appellate court, therefore, on the basis thereof, held that there was a delay which was not duly explained, and as such rejected the said application. The consequential effect of the said application being rejected was that the appeal was also dismissed. This court have duly heard the learned counsels appearing on behalf of both the parties. The learned counsel appearing on behalf of the appellant has drawn the attention of this court to the judgment of the Supreme Court in the case of
Lordship. Condonation.
Hmm?
Recently, Lordship. Recently, I'm not aware.
Submitted that it is a well-settled principle of law that the that the that the courts, while exercising the jurisdiction under Section 5 of the Limitation Act, is required to take a pedantic approach and it's required to liberally construe the delay, liberally construe the delay in filing the is a well-settled principle of law that the learned that Section 5 of the Limitation Act while adjudicating the provision of Section 5 of the Limitation Act, the learned courts are required to liberally construe the explanations. The fact that the petitioner had categorically stated on affidavit that she had no notice till 3/12/2014 when she was evicted from the suit room, and thereupon the materials on record would show that the petitioner was diligent, the appellant was diligent in pursuing the her legal remedies was apparent on the face of the record. The learned counsel further submitted that merely on the ground that the learned trial court, the first appellate court, did not take into consideration without even examining the Nazir who had submitted the report on 7/11/2014, had presumed that the Nazir had visited the said suit room and submitted the report. There was also nothing on record to show that the Nazir met the appellants on 7/11/2014. The learned counsel therefore submitted that the learned first appellate court ought to have condoned the delay in filing the appeal. Per contra, Mr. A. Sattar, the learned counsel appearing on behalf of the respondents, submitted that although the provisions of Section 5 is to be liberally construed, but the explanation of the delay has to be proper. He submitted that the explanation of the delay in the instant case was not at all bona fide, taking into account that the respondent appellant failed to taking into account that the appellant had due notice on 7/11/2014, if not earlier, from her earlier counsel. This court have given an anxious consideration to the respective submissions in respect to the first substantial question of law so formulated. First, the materials on record show that the appellant had categorically stated that on 3/12/2014, the appellant came to learn about the judgment and decree on the ground that the earlier counsel who contested on behalf of the appellant did not inform her. First, it is further seen that immediately after 7/12/2014, the 3/12/2014, the appellant took all necessary steps with due diligence, which aspect the learned first appellate court ought to have taken into consideration while construing, while deciding an application under Section 5 of the Limitation Act. First, in the opinion of this court, the judgment of the order passed by the learned first appellate court rejecting the application, order dated 31/8/2017, by which the application filed under Section 5 of the Limitation Act, Section 5 was rejected, of the Act of 1963 was rejected, appears to be in a manner very hyper-technical, in a manner appears to this court that the learned first appellate court had taken a very hyper-technical approach, which is not the law as laid down by the Supreme Court in various judgments. Considering the above, in the opinion of this court, the first substantial question of law is duly involved in the instant appeal. This court further duly takes note of that the second substantial question of law is a question of law on the merits of the appeal. It is on merits, taking into account that both the parties would lose a chance before the, taking into account that this court, taking into account that the second substantial question of law would involve a decision on facts which the first appellate court would be better suited to address, taking into account the limited scope under Section 100 of the present proceedings, 100 of the code, taking the limited scope of this court while exercising the jurisdiction under Section 100 of the code. This court deems it proper that the appeal is required to be remanded back in terms with Order 41, Rule 23 of the code. Accordingly, the instant appeal stands disposed of with the following observations and directions. Number one, the application being petition number 443 for condonation of delay under Section 5 of the Limitation Act 1963, filed before the learned court of the Additional District Judge, Kamrup Metro at Guwahati. Kamrup Metro Additional District Judge number?
3.
3. 3, na?
Yes.
2, my lord.
3. 2 or 3?
2, my lord.
2.
Additional
2. Additional District Judge number 2,
Two,
Kamrup
Lordship.
Metro
Two.
Guwahati is allowed. Number 2. The appeal, therefore, the appeal being titled Appeal number 12/2015 is restored to the file of the learned Additional District Judge number 2, Kamrup Metro at Guwahati. Number 3, the appellant, the learned first appellate court, that is the learned court of the Additional District Judge number 2, Kamrup Metro at Guwahati, that is the learned first appellate court, shall decide the appeal on merits. Number 4. Taking into account that this court had exercised the powers under Order 41, Rule 3023, This court further, in exercise of the powers under Order 41, Rule 26, directs both the parties to appear before the learned First Appellate Court on.
My lord, may I suggest one thing, my lord, that ADJ number 2, additional district judge number 2, now will become, my lord, the civil judge because of the change of pecuniary jurisdiction, my lord. At that time,
On
because
16th of July 2025. আর আগতে এটা লিখিব লাস্ট অফ হলে দিব না এপিল নয়
should
now what is the jurisdiction has changed
my lord, earlier it was 5 lakhs, now it is 20 lakhs.
তার উপর লিখিব is required to be remanded under order 41 rule 2023 of the court bill লিখিলি নয় উপৰত লিখিছো নয় পুস্তক at this stage it has been submitted by by the learned counsels appearing on behalf of both the parties that in view of the amendment made to the Bengal Agra's Assam Agra Civil Courts Act 1887, the jurisdiction, the appellate jurisdiction now would be before the court of the civil judge.
Yes, my lord.
Civil judge, senior division, taking into account senior division,
My lord.
taking into account that the value of the suit is less than rupees 5 lakhs. Isn't it?
Yes, my lord, yes, my lord.
Push. But how did it go to that district judge? How did it go to the district judge at all?
That itself was wrong, my lord, at that time, because 450 is that room value, good value.
My lord, there was an administrative order by the court.
Huh?
In the,
No,
That time
understood,
there was
but
an
how could
administrative
it go to the additional district judge? Because obviously, at that point of time, it would be less than 2 lakhs, 2015.
yes,
450.
yes, my lord,
below.
yes. Less
So if
than
it-
2 lakhs of the municip, 2 lakhs and below municip, my lord.
2 lakhs, less than 2 lakhs.
Yes, my lord.
So therefore, the appeal will lie to the civil judge only.
Civil judge.
How the appeal was filed in, this is the wrong court.
No, my lord, at that time, there was an administrative order by the Chief Justice of the that the appeal should be made. to the
All
district
appeals,
judge.
yes, all
Before the-
appeals should be.
All appeals should be made before the. That was
My
the-
lord, that was a transitory
Oh.
period, yes.
Okay, okay. এইটো এটা কাম কৰো সেইখিনি নিলিখিব এই লাষ্টৰ এইকণ যে কলো সেইখিনি নিলিখিব এই লাষ্টৰ খালি এই যে না এইখিনি বাকীখিনি লিখিব অনলি সেইকণ যোনখিনি মই কৈছো যে এতিয়া আফটাৰ অৰ্ডাৰ 41 rule 23 সেইখিনি নিলিখিব তাৰপিছত I will appear before the learned court of the additional district judge and so এইখিনি কলো and so.
16.
Three.
But is the additional district judge number 2 there or not?
Now there is, my lord. And there are four additional district judges.
The 2 is there.
Who is there, my lord?
Let it go to 2.
Okay, my lord.
Because they can still exercise their jurisdiction.
Yes, yes,
The
yes.
district judge. LCR be returned so and so.
There is an injunction.
LCR be returned It shall appear on 16th of July 2027 for the learned court of the additional district judge number 2 Kamrup Metro at Guwahati. Then next likhibo the registry shall also ensure that the registry shall forthwith return the records to the court of the additional district judge number 2 Kamrup Metro at Guwahati, the learned first appellate court. Court first appellate court will shall return the records and ensure that the said records are available with the learned first appellate are available before the on or before the next date so fixed herein above. Next. This court further taking into account that the appeal has been allowed, it is further taken note of that during the further taken note of that a cost of rupees 15,000 was imposed upon the council. Upon the council. Did I impose upon the petition council? No. Before parting with the record, this court observes that when the instant appeal was taken up in the first half, none has appeared on behalf of the appellant. And as such, the appeal was an oral order was passed for dismissal of the appeal. However, at the before recess, a mention was made for taking up the appeal, and there was a difficulty on the council to appear when the matter was called. This court had taken up the appeal on the condition that a cost of rupees 15,000 be deposited before the registry of this court. It has been brought to the attention of this court that the said amount have been duly deposited before the registry. Taking into account that the appeal has been allowed and this court directs the registry to refund the said amount to the learned counsel who had deposited the on production of the receipt.
Direct the first appeal to dispose of the first appeal within a span of time, Lordship, if possible, Lordship.
Let it go. This is very difficult to say that.
2017 to 2025 only before this court.
Understood. But then also,
Apply.
I'll give you the direction. Tomorrow you don't appear there. Same. Then
Apply.
Item 6 and 7.
in fact, in my opinion, the judgment of the Supreme Court making this point, it should have been earlier, it was revision. This is a case of actually a revision. It is not an appeal.
Not an appeal here.
This judgment of the Supreme Court has created a lot of problems. This
But
2001.
my lord, this honorable court through the hands of Justice B.D. Agarwal has said that it amounts to a decree and so appeal lies, my lord.
Not only that, the Supreme Court say
Yes,
earlier there was a Calcutta High Court judge, full bench, which
Yes.
says that appeal does not lie. Calcutta High Court judgment is based upon a Lahore judgment of 1942. It is not an appeal because you have to therefore challenge that section 5 odd.
yes.
But in 2001, the Supreme Court said no. It amounts to a decree and it amounts to a confirmation of the decree
So,
passed by the learned trial court. And as such, the substantial question of law has to touch on the decree. Although today in both the cases I've allowed this in these, but in fact, substantial question of law, it is actually a question of fact. As to whether a sufficient cause is made out or not is a question of fact.
Fact.
Unless it is a perversity.
yes, my lord.
But there is no perversity here. in both the cases, his case or that case. The earlier case I allowed only for the purpose that the plaintiff is more harmed. Who won the case, he would be more affected. Mr. Mazhar Bhuiyan's appeal be, if it is dismissed, he should have been more happy. Because of the fact, if the appeal is allowed, what the problem which happens is the trial court passes a judgment and decree declaring right title and interest and directing for making a survey in the execution stage. How is it?
That is not.
That is unheard of.
Yes, Manoj.
So therefore, if I restore that appeal, he gets a chance now to file an order 41 Rule 20. Whether he files or not, that is his. I am here to advise.
Item 6 and 7.
That day I was looking into it. There are 2-3 judgments on your case. That is, one is a Supreme Court judgment. That day I took it out, then I forgot. Man, I got it out. One is a judgment wherein it categorically says that this pension and all will go as per the regulations.
Yes, I have a couple of judgments, perhaps.
One judgment, Supreme Court judgment.
Yes, ma'am.
Not by the succession business. One. The second is, you see, look, very interesting. I was reading it. I could read it half. I couldn't get the time to read it full. Now in America, what is happening? You see, your 1925 Act is made on the basis of the British common law. Now, the same principles were also applied in America. So they were having that. Huh?
Right.
And they said, because you have to understand the Indian Succession Act is not for Hindus.
Yeah.
It is for Christians. Muslim takes it for themselves. So Indian succession is mostly for
Basically for the. This was one judgment, the Me Too versus Sheila Rani. This one specifically said, here the dispute was between mother
yes,
and
Justice
Yeah.
Dave's judgment.
mother and wife.
Huh?
Here the dispute was between mother and wife. So mother was also a class 1 higher. High Court had held in favor of the mother, divided it 50-50%. But the Supreme Court has granted the entire pension to the wife.
Yes, this
Yes.
Justice Dave's judgment.
And this follows the Violet Isaac case of 1991, which I've also copy I've given. That specifically says that the pension, since it is not the personal property of the deceased, he cannot make a will. In Violet Isaac, what happened was that the deceased made a will and gave everything to his, including the pension, to his brother. So the widow came. Apparently, there was a strained relation between them. So everything went to the brother. So the widow came up to the Supreme Court and said that it cannot be like this. And I being the wife, and that status is not disputed. The Supreme Court held that he cannot make a will because it is not a part of his estate. So my learned friend would be right in contending that the mother and sisters would inherit his immovable properties. Everything which is immovable, which is covered by the Succession Act otherwise, that they would inherit, there's no doubt.
DCRG may be a part of his estate.
Yes, DCRG bank has already appropriated. So now we are not.
That's another thing, but that is a part of the estate.
Yes, that they could have gone and claimed. I could not.
But the
claim that.
family pension, a pension is his estate, but a family pension would not.
Family pension would not. And family pension, the very logic, there are a number of cases lordships are aware. The family pension is given under the circumstances to the dependent family for rescuing them from the destitution part. That is the reason for the family pension. It has to go to the dependents. Irrespective of whether they are class 1 IS, class 2 IS, it has to be a dependent. And the regulation herein is very clear.
Now, let's see what the first appellate court says. Where is the first appellate court judgment? Yeah.
First appellate court judgment in the first case starts from page 7 onwards.
Which appeal?
Well, this is the first one, 260
Huh?
of 260 of 14. In fact, first appellate court has more or less copy pasted most of the portions of the judgment. Most of the judgment of the first appellate court
Is a copy paste of
is
the
a copy paste of the judgment of the.
It is crystal clear that so and so is not the legally heir of heir in the eye of the minor so and so, born out of the long and continuous, however, entitled to get a share of the self-earned property of the deceased father, including the share of the family pension. The defendant number one is directed to take into consideration the decision of this court while disbursing the pension and other benefits. Made clear that the defendant shall be governed by the relevant pension and must take into consideration the conclusion arrived by the court. So this is, therefore, no, it came to my mind, the direction which is given is also in respect to not the anything else, but as per the rules.
Yes, directing the bank to keep this direction in mind while considering the issue of family pension. But then the issue, the bank as such perhaps found it very difficult and bank has not taken any decision on it. So the reason that these two appeals now subsist is on the additional question of law that your lordships have framed as to whether the appropriation that was done by the courts below was proper. Because the courts below, both the courts have now my right as a child, as the son of the deceased, is not in dispute. That has not been challenged by the other side. So
Why there are two appeals?
Because one suit filed by them, one suit filed by us.
You have filed both.
No, I have filed one, the other suit filed by them.
Why he has filed?
They have also filed to declare the mother and the sisters as the legal heirs and entitled to all the service benefits.
So they want the entire thing.
Yes, they want that.
That you should not get.
Yes.
Means the son also should not
No.
get.
They have said, they have denied my right.
That's
as
your
a son.
appeal.
That was my appeal. Yes.
And your appeal is that you should only get.
Yes, an injunction against them. An permanent injunction against them. Declaration in our favor and permanent injunction restraining them from claiming the benefits.
Of the family pension.
Of the family. Family pension, in fact, it was not worded as family pension, it was worded as a service benefit because at that point of time, the other benefits were not appropriated. Those were gradually appropriated because of the loans. Now, 260 of 14 arises out of their suit. The TS 18 of 7, which they had filed. And the other, the RSA 43 of 15 arises out
So
of.
did they file an appeal?
No,
First
they have
appeal.
No, they have not filed any. They have not filed any appeal. I have filed both the appeals.
Our suit was decreed that.
Their suit was decreed. Theirs was decreed, ours was dismissed.
No. Who has filed two appeals?
I have filed both the appeals.
That is what I am asking you.
Yes.
He has not filed any appeal.
No, they have not.
That is why. So he is not questioning yours entitlement.
Yes.
The son's entitlement. He is not questioning
No,
that.
No, he's not questioning.
Now you are here before the court
Yes.
saying that the entitlement should be sold to you and depriving them.
Yes, mother and others. But as I see it, these two appeals, second appeals were filed basically on the question of validity of the marriage to show that the appellant number one also had a share as a legally married wife. But after going through everything, it is clear that that claim perhaps has no legs to stand in law. So I have given up that claim as far as appellant number one is concerned. Now appellant number two, the son, who has now attained 25, almost 24, 25 years now. There is no doubt that he is the son or the child, and that is not disputed by them. So that's the admitted position that he qualifies as the child under the bank regulations. And the bank regulations are very clear that if there is a...
Mr. Sharma, tell me one thing in this case. For the central bank, except the family pension, all other amounts you have already taken for the loan?
Yes, Your Lordship.
There is a loan which was taken by the father, the father of the plaintiff, of this appellant. So that loan has been already liquidated?
No.
Still remains.
fact, bank has issued surface notice also. in that. Now only the question of family pension. And that was by way of interlocutory application was challenged. 1297. So far as challenged, no, but that was one of the earlier learned counsel appearing in the matter had brought that surface application to show that there was a marital relationship between appellant number 1 and the deceased. I don't know, but I am not
They issued a surface to whom?
to Rinti Musahar, appellant number 1. Appellant number, as the wife. So the learned, my learned predecessor in the case, he produced the notice to show that yes, they are treating her as the wife. That of course, would not aid my claim as a legally married wife. I'm not relying on that at all. My claim is only based upon now the appellant number 2, who is undisputedly the child, the son, and he is entitled to the entire.
Now, how much is the central bank entitled to?
4,30,332 as on 10/12/2018. So it would be around 10 lakhs rupees now.
So are you giving interest on the amount which you are keeping? You are holding into certain amounts you have not disbursed.
So Lordship, if it is permissible within that personal law, then it will be entitled for. Otherwise, I do not say that they will be entitled for. Because whatever the amount is under some scheme, might be pension or retirement benefits or like that. I do not think so that carried any interest.
No, I'm not on that. But you are withholding that amount.
Your Lordship, if the lawful claimant will not come up with the proper documentations with us, how can we disburse the amount to them? Because it is their duty to prove that they are.
But once you have gone for a surface proceeding,
Yes.
you have
We
made
require
it an NPA.
Huh?
You have made it an NPA.
Yes, Your Lord. We have to make it NPA, otherwise we cannot initiate surface here.
So once you make NPA, can you further add interest?
Your Lordship, yes, we are entitled to interest, but we cannot debit in the account only this. This is only an accounting purpose. We are entitled for the interest whenever.
Did you stay to the surface proceedings? No.
No.
So are you not barred now to take action against that property, that amount?
No, Your Lordship, it is still under limitation.
How?
No, that question again another question. That is 1/1/2007 is the NPA date.
So then,
But bank has issued surfacing
Bank
notice
may do,
on
that's a different thing.
10/12/2018 within 12 years.
so therefore the question is, his DCRG benefits and all you have withheld.
Appropriated minutes, not with.
You have appropriated or withheld?
No, Your Lordship, it has been appropriated. I think.
Appropriate. Then after appropriation, this is the amount
Might be.
pending.
I have to go by the statement. This is the amount after the DCRG, leave encashment and GSLI.
So you have anything out there to show how much it is? And I can see some judgments you are bringing. What are those judgments?
Regarding judgment, Your Lordship?
You see from here some judgments.
No, Your Lordship, at that time when the interlocutory application was filed, then at that time I was prepared for the matter that this interlocutory application is not maintainable because if there is an co-owner in the properties, then this cannot be decided except the DRT only. So these are that only the Jagdish and Hiralal judgment is there with this. So this application is not maintainable if they are challenging the surfacing. In the case, that would be beyond the scope of the appeal. I cannot face such a. But in the appeal, their question is different, but in the.
Now tell me here, you are the main problem. You are the main solution.
Yes.
You have defined child. Child is defined, huh?
Yes, it is under the regulations, Your Lordship.
Now, do you take out
Child is
illegitimate child out of it? Do you take out illegitimate child?
No,
from
there
the-
is no definition of illegitimate.
So there is no illegitimate child.
No. Child is a child. There
Child
is
is-
no illegitimate. or
Means
legitimate.
a child of the employee. So if a son is under 25 years of age and if a daughter is unmarried, and is under 25 years of age, and expression children shall be construed accordingly. Now, the family includes the wife in the case of a male employee or imam, son or daughter, including adoptive son. So therefore, adoptive son or daughter legally.
Yes.
So as per you, whether a child who is this petition number plaintiff number 2 now.
Appellant number
Yes.
2.
Appellant number 2, as per the ban, would he be entitled as per this regulation?
Your lordship, as far as the rules is saying, he is entitled.
So if he is entitled to the family pension, we are concerned with the family pension only.
Yes, yes, sir. Only family pension.
Family. So if he is entitled to, then nobody else can be entitled. And what about the wife? Wife would not be entitled
Your lordship, wife will be
because she's declared
She
to
is
be
within the
illegal,
family.
illegitimate.
illegitimate. That then Hindu law, I think, this.
No,
whatever the
Hindu
law
does
will
not
be
come here.
Yes, your lord.
Hindu is because section 16 is.
Because your lordship, wife is also not saying in the rules that illegitimate or legitimate wife. Rules does not say so.
No, 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 no. There is a declaration that he is the illegitimate child, wife.
Okay.
See, there is a difference. A wife may be illegitimate. And if the wife is illegitimate, the offspring, would the offspring be illegitimate?
Offspring, I think, cannot be. There is. Offspring always be legitimate. But, they are legally entitled. Regarding children, no. There is no.
But Mr. Ganguly, why are you saying that the wife would not be?
Because of the.
We go by the fact, same argument which you are making. A son would get, even if he is illegitimate.
Yes.
But a wife would not get if he is illegitimate.
The reason is this, my lord, that though my learned friend has been very liberal in saying and correct in saying that it has not been defined as wife. My lord, if you go by the reasoning and the evidence in the learned courts below, it has been held that the marriage was between essentially a Christian man and a Hindu woman. And that marriage, my lord, has been held to be a void marriage. Because there
It's a
was
void marriage.
yeah, because there was no conversion of the Hindu, the Christian person to the Hindu religion. And there is judgment of the Supreme Court, my lord, in a very similar case. I think Justice Aftab Alam's judgment is there from an appeal from the Madras High Court, which said that such a marriage is a void marriage. So, my lord, as on today, now my lord, much water has flown down.
Now, if it is said to be a void marriage,
because that is precisely, my lord, that is because
that's a finding of fact.
it's a finding of fact, my lord, and that, my lord,
So
perhaps
if it is a void marriage, then it can be a wife.
It can be.
because,
But
my
an offspring of a void marriage then also would be a child.
yes, my lord, the second limb of the argument is this, my lord, that let us say, my lord, had it been a case of a Hindu only,
And he is
but
a
the
minor.
second wife, let us say he had two wives, and the second wife, and the first wife doesn't have a child. But the offspring of the second wife will also be, my lord, considered as a offspring for the purpose of the.
This is because of 16.
Because of 16, my lord.
But if that is not given here,
Yes. But that we need not go into that here, my lord, because the fact of the matter is that these rules, my lord, do not distinguish specifically between us.
we go into the aspect like this is a secular,
This is secular,
similar like the JJ Act
like the,
for adoption.
yes. But because of the aspect of, my lord, voidity, my lord, as the appellant number 1 is the own mother of appellant number 2. So, my lord, there is no conflict of interest as such. My lord, the evidence before the learned.
So there is a difference. If the appellant number 1 gets it, she gets it throughout her lifetime.
Yes, she gets it.
But here, this person will
only
only
get
get for another 2-3 years.
That's a fact. But the fact is that, my lord, if we, my lord, in the case of the wife here,
it perhaps cannot be interpreted to mean a void marriage, a marriage which has not been performed, because my lord, under what act was the marriage performed? Neither the Christian Act, nor the Hindu Marriage Act, nor the Special Marriage Act. So now it will be difficult for the appellant number one to sustain that aspect of the matter.
Okay, let us hear Mr. Hawk. Where is that?
It is reported.
Name? In fact, there is another very recent order of Kerala High Court. There it says a person concerned, she was a Christian, this is Christian. She was an illegitimate child. She want to get the, what do you call that? We get the succession certificate. So she applies, which was not given. Then the Kerala High Court gave it, duly recognizing that aspect. Now, anyways, he wants to show two judgments.
Paragraph 22.
Paragraph
In
15. Which one? 2000? This is R. Muniadi.
yes.
What is this?
In 15, my lord, a relied.
The case out here, maybe. No, understood.
Right.
For the purpose of Indian Succession Act, he would not.
No.
What do you say about these regulations? In view of this judgment
If you
of the
regulate,
Supreme Court, which says that pension, family pension scheme and has to be decided on the basis of the scheme. How do you take care of this?
but this pension and other benefits, that are the property. So succession act will come, to my understanding.
No, pension, family pension would not. Because it is not his person's property. It has, whatever may be, the pension has to be regulated as per the scheme.
That is regulation of the bank.
Now, the regulation of the bank says son.
It is not defined as legitimate or illegitimate.
There the problem arises.
There is the problem.
Because, yes, as per Indian Succession Act, he may not.
May.
But taking into account this judgment of this Neetu versus Sheila Rani or this Violet, Isaac and all, this has to be regulated as per the scheme.
That is,
If that is the scheme, then how do you take care of it?
so far as son is not defined in the regulation manner, that is on.
And more particularly when the judgment of the, because you are not on appeal.
No,
Now the judgment of both the trial court and the first appellate court
as per the pension rule or.
rules, and again observe whatever it is. Whatever it is not made clear.
But if
They, in fact, both of these judges should be brought and asked to exercise 226 would have been more better,
clarified.
isn't it?
Clear.
Taking into account that 226, you can say many things. There should not be, but when you are delivering a judgment and decree, it has to have the clarity.
Clarity.
So this is, in fact, I met a very, one of a judge from Jharkhand High Court. So he was also telling me that you see the difference between civil proceedings and in a 226 also proceedings, we have to also pass the decree. When we say after passing everything that okay, we set aside this and all, you should also, while writing a judgment, you should also say that what you have allowed, what you have not. Because the principles of the CPC has to be always there. Then only you can give effect to. Not if you are doing a contempt against in a judgment which is not clear. In fact, that is the problem. I therefore say that these both of them should be given 226, this jurisdiction. If you are filing a contempt, how do you do it? Tomorrow, how do you enforce the decree? You can't enforce the decree. Asking them today, they will say that how do we do? So then the executing court cannot go behind the decree again. Just for example, today I don't say, okay, appeal dismissed. How does the executing court decide?
Then also problem.
The executing court can't do anything.
And even they have a, if
Because they cannot, in a position, in terms with these rules, because on one hand, the rules is being applied, and on one hand says that these people are not going to get. Chalo.
even they are not agreed, cannot be agreed against the judgment because there's an order, specific order that it will be governed by the pension.
No,
To that extent.
but tell me one thing. Would you like to be affected by the surfacei? Are you going to take the burden of the surfacei?
That is,
Tell me, you take his properties, you took everything you want to, you take it.
Right.
But then you don't want to take the burden of the surfacei. This is a very important thing which you are not willing to pay. Because the moment, whoever it is being given,
and that
their bank will then,
attack.
although it is a different thing, that the bank may be limitation, there might be all this, unless there is a stay from this court. If there is a stay from this court, it's a different aspect. But it seems that in 2007, it has been, and then the surfacei also the Limitation Act applies. So these are other things. Lien on what? Credited in the account from whom? Oh, we'll see that.
Really involves the second round of litigation.
Huh?
It seems to me that there is a second round of impending litigation.
Who is going to file? To take that benefit?
That burden I can.
Huh?
That burden I can.
Because the moment it comes to
Yes,
you, the money will go.
Yes.
Because he will go into
You
the
will attack me.
Chalo. We do one thing. I have three CABs. List the matter on 10/1/6/2025 at the top of the list. We'll finish it on that. Actually, I don't get the time to see a judgment to that. Because this judgment is a clincher.
But I should have got that earlier. I was aware of this judgment.
Because this is because that day while going through, I found that this is the judgment. Now once it has to go by these rules, it has to go by this.
Yes.
And it says that it is the okay, let me write anything. Oh, you. Huh?
16(6), Lordship. Item 16.
Ah.
That Lordship, we have preferred appeal against preliminary decree, and the first appellate court held that my appeal is barred by section 97. That case, Lordship. So Mr. Sikdar is it so?
Item number?
Item number 16, Lordship. Any other date?
Oh, that matter.
Yes, Lord. The trial court execution is pending on 16/6. Before that, any.
16?
16/6.
Is a RSA?
Other side, Lord.
What are another matter, RSA 92?
Lordship, that is regarding, I am dependent, both the courts decided against me. I am saying that I am the occupancy tenant and they are saying that I am the permissive possessor, Lordship. Eviction of the appellant, decree was granted, Lordship, against that. Your Lordship has fixed this matter at 2 p.m, Lordship.
2 p.m. I have fixed this and the other one also, no?
Yes,
152.
Lordship. But in item 16, Lordship, execution is pending, and in item 15, there is no execution proceeding initiated by the plaintiff's Lordship.
Item 15, there is no urgency. Urgency,
Lordship. No, Lordship. Item 16.
you are in possession.
Lordship.
Item 15 to Laila with you. 16 to DDO on 3rd,
Lordship.
2 p.m.
Oblige.
Yes, take this. It may help you.
I set